a seat, please. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. All persons having business with the Appellate Division drawn near to the attendance and you shall be heard. Please be seated.
Good afternoon, everybody. Welcome to the Appellate Division, First Department. We do have over 7 hours of argument time that has been requested, so on the theory that you probably do not want to be here till 9 o'clock tonight, and nor do we, I ask you to please limit the amount of time that you request to what you really need to just explain your major points to us. Remember, we have had your briefs and records for a while and are familiar with the facts of your case, and we just hope you'll be able to answer some questions for us. Okay, let's start with the call of the calendar. The first case, People versus Darrell Jenkins. Okay, I'm going to give you 6, 2, and 6. Thank you. IHG Harlem versus 406 Manhattan.
Appellate, 4 and 2.
Okay.
Respondent, 5.
Okay, 4, 2, and 5. Thank you. Y. Edward versus Jessica H. is submitted. Hess versus Fabrici. Submitted. E.S. an Infant by Windsor Owners. Okay. And we have 2 respondents here.
Respondent Martina Andrea Search, 5.
Okay, and plaintiff? Okay, thank you. People versus Guzman. Submitted. Advanced Alternative versus Hindlin. Okay, respondent?
Respondent requests 7 minutes.
We're going to do 5, 2, and 5. Thank you. Nava versus Franklin.
Appellate, Your Honor, 5 and 2.
Okay. Okay, 5, 2, and 2. Thank you. People versus Lamont Robbins.
Appellate requests 4 and 1, please.
Respondent?
Requests 4.
Okay, I'll give you 3, 1, and 3. Thank you. Carey versus Carey. You are whom? You're, okay, and where are the respondents here? That's what you said. Okay.
I'll take 5.
Okay. Which response? Okay. And for the. Okay. So I'll give you the appellant 6 and 2, Mariah Carey 5, and the other defendant 6. Okay. EPAC Technologies versus John Wiley and Sons. I know defendant has an appeal and the plaintiff has a cross appeal.
Yes, defendant appellant respondent requests 6 and 3, Your Honor.
Okay, and okay, I'm going to give you both 5 and 2. Thank you. S. Robert versus Norma C. Who? And the other parties aren't here, but you want to have 3 minutes in case we have any questions? Okay, so that's just for the attorney for the child. Thank you. People versus Tony Floyd. Submitted. Farrelly versus the State of New York. Respondent? Okay, I'll give you 7 and 2 and 5. Thank you. New York Holdings versus NYPD. Okay, and okay, I'll give you 6 and 2, 6 and 2 and 5. Shapiro versus 89th Street Development. You got it, 4, 2, and 3. People versus Jesse Badillo. Okay, and the appellant's not here today? Okay, we'll mark it a submission, thank you. People versus Wilson. Submitted. Tudor Perini versus Port Authority. Respondent? I'll give you 6, 2, and 6. Thank you. People versus Vargas. Submitted. Char versus Arab Bank is submitted, and Johnson versus Johnson is submitted. Okay, we are going to take one case out of order. Advanced Alternative versus Hindland is going to be argued first. I am recused from that case, and Justice Schulman is vouched in on that case. So if counsel will come up, please. Thank you, Jeffrey.
Okay, you may proceed.
Good afternoon, Erin Karpinski-Herster of Foster Garvey on behalf of appellant defendant Jacob Kasher Hindland. May it please the court. The plaintiff in this action is not entitled to partial summary judgment on its contract case because it failed to make a prima facie showing based on admissible evidence.
What effect does the prior action that your client commenced have with respect to the issues in this case? Because he brought a brief, if I'm not mistaken, and correct me if I'm wrong, a breach of fiduciary claim against
Yeah, that's right.
the other side?
That's right, he
And
did.
lost.
That's right. And so that was a case about a duty that was outside of the terms of the contract. It was a tort claim for breach of fiduciary duty. And this is a case that is an affirmative case by the defendant in that case saying, you breached the contract against me, so I want to recover. And so
And what's your defense to that breach of contract claim?
well, the breach of contract claim for purposes at trial or purposes of this hearing.
What do you use as a defense to you breached the contract?
The contract is that he did not perform as required by the contract, and that
Right, that's what they're saying, right? That your client didn't perform, right? They sued you for breach of contract in this case.
but they have to prove that they performed.
Okay,
also.
assuming arguendo that they did perform the contract, what's your defense to that?
They have to prove that first.
You didn't hear what I said. Assuming arguendo they did prove the breach of contract, what do you need to do to get around that?
Then we go to trial on damages.
Okay, I got it. All right.
Yeah. So I mean, it's a different standard between whether you are defending against a breach
I
of
understand the
contract.
standards. I understand what the burdens are. I was just curious. What was your argument if they had proven, even at trial? Let's say go to trial, and they proved the breach of contract claim against your client. You have to have a defense, right?
Well, our defense will be based on expert witnesses saying that that is not what was required by the contract, but assuming arguendo that they overcome that with expert testimony.
What's
of
your
their
next
own.
defense?
That is then.
That's it.
then
I
we're
thought,
talking about damages.
I thought you belatedly was advancing a faithless servant obtusely in this action. In other words, if I'm not mistaken, in the pleadings, and I think the court below tried to address that issue, found that there was a cursory reference in paragraph 20, 28.
Right, and
I think
that
what-
was dismissed.
I think what my learned colleague was raising is, are you attempting now to advance a faithless service defense, yes or no?
No.
Ah.
We are talking today about the summary judgment standard and how they asked the court to search the record because they did not put in evidence of performance of the contract into their moving papers. And that is black letter law for under Alvarez and a million
What
other
inference
cases.
should we draw from the fact that the management agreement was extended by your client? I mean, doesn't that imply that there had been performance in the first part of the contract?
But for the first part, it implies it, although we would have defenses to it if they had raised that as this is the performance. But they didn't cite to any performance in their briefing. They just attached the management agreement and the extension. Now, what they really want
Isn't there a lot of record evidence reflecting that there was a lot of back and forth between your client and the principal of the plaintiff? I mean, I thought there's an EBT, there's emails, stuff was going on. It wasn't like they weren't doing anything with respect to their management obligations.
So and he has paid a lot of money in commissions for all of that.
So that
work,
you wouldn't
but-
have done that if there hadn't been performance by the plaintiff.
But there is, what they want to recover is millions of dollars for a transaction that happened in 2018 after the termination of the contract, and for which we allege that AAM acted against the interest of my client, and that's what they're trying to
Yeah,
get.
I was just pushing on your argument that there was no prima facie made out. That's what why I
Yeah,
invoked
and
all
so
of that.
I don't think that the extension by itself, before those actions occurred and before, while all of the facts were not known, that there wasn't some amount of action, there's an inference of it. But there's no reference to that in the briefing saying we performed the contract. It attaches just an extension.
Thank you. You have rebuttal time. Thank you.
Good afternoon. May it please the court. Mark Zouderer for the respondent. I'll address each of those points that the court's raised, but what's been stated is just factually wrong, I submit to you. These parties operated for 7 years under this contract. It was actually renewed till it was terminated. I'll address the affirmation technical arguments in a moment. But first, let me point out in the record, there was a verified complaint in this action. It's at the record, page 298, paragraph 33. The allegation sworn to and verified was AAM has performed all of its obligations in accordance with the terms of the management agreement. That on summary judgment is a proffer of testimony. That's what we do on summary judgment, which is the equivalent of a witness getting on the stand and making that prima facie case. There's no defense to it. In fact, there's nothing in the record other than the one defense which has been discussed here, which was rejected in the prior action, and it was affirmed by this court.
The faithless servant
Yeah, that was-
argument.
all right. So let's address the technical argument. They say, Zouderer, Owen, you submitted an affirmation. You didn't know the facts. Well, we know what affirmations do. We don't purport to talk about the facts in the underlying case. The affirmations before the court, which I'll show you, are pointing to documents of which we have personal knowledge and the prior decisions of the court.
That's what I kept pressing your adversary is like, assuming you've prima facie, assuming we even go to trial in this case and you've established breach of contract, what's the defense to it? What do you have left that you can challenge? And she brought up, well, the experts can argue about this, that, but what if that all fails? What else do you have? Can you point to? If the contract is unambiguous on its face, you don't need experts to tell us.
Sorry, Your Honor. What you're interesting, if you look at the table of contents of their brief, they don't even challenge the collateral estoppel. It's all this technical argument, which I'm going to address if I have a couple of minutes left, about the affirmations and what's in the record. And I've cited to you now what's in the record with the verified pleading, which is the equivalent of testimony. We have Hindland's attorney sending a letter in 2017 to AAM terminating the management agreement after 7 years. He says, Jay Kosh, that's the name of Hindland in the industry, Would like to thank you for all of your efforts on his behalf over the years. And that document was part of my affirmation at Exhibit 3 in the record at 160. Next, the record on AAM's motion below included confirming deposition testimony of Hindlin himself, in which he acknowledges AAM's work for him under the management agreement. All, I submit, admissions of performance. He says as follows, this is Hindlin, I always brought everything to Mark, that's Mark Bevan, one of the principals of AAM, as far as business stuff. Mark would always be in the middle of it or kind of conduct it or just tell me he would handle it, record at 392. Quote, it was always Bevan who was doing the negotiating and figuring everything out, record at 396. In fact, by the way, Hindlin's opposition brief below on summary judgment did not argue that AAM failed to submit an affidavit by a person with knowledge. I mean, this was just brought up on appeal, but it's just simply wrong because our affirmations was to bring before the court the matters that were of record on this appeal.
I think the lawsuit that was commenced by Mr. Hanlon really, I think, boxed him into a corner. Mr. Hindlin, I'm sorry.
Yeah.
Boxed him into a corner, especially after this court affirmed the dismissal of the action, because that all rose out of the fact that your client cut a deal with the prescription, LLC.
It all grew out of their performance. I mean, that's the whole point, so they performed and they have no defense to it. And what's going to happen, by the way, there's a jury trial coming up before Judge Maisley in January, which is the damages trial. They owe money and it's going to determine, and they're going to have an opportunity.
It's only just liability at this point.
Yeah, it's just on liability that they owe some money and that we made a prima facie case that they owe money, a liability under the
Yeah,
contract.
because if there were truly a breach of contract, that action commenced by Hindlin would have asserted a breach of contract claim.
Yeah.
It just asserted a negligence and breach of fiduciary duty.
Yeah. All right, unless the court has any questions, I have nothing.
I don't know, anybody on the bench? Nope. Okay, thank you.
Thank you very much.
I just wanted to make 3 quick points. First of all, the verified complaint says AAM has performed all of its obligations in accordance with the terms of the management agreement. This conclusory statement is not sufficient to raise a prima facie case. Second of all, and that is in the record at 298.
Well, that concludes the same thing, that they complied with all the terms of the contract. I mean, it's a motion for summary judgment, simply can just say, no, hang on a second. Here are the factual issues. They didn't comply, and take off at least one problem with that kind of conclusory statement, saying, okay, it's concluded, but let me tell you why it's conclusory, because I'll give you this fact issue here.
And that's
like
what
I said,
we're trying to do.
Go ahead.
And the second thing is that the reason that the first action didn't bring a breach of contract case is because the prior counsel did not give sufficient notice under the agreement.
That's outside of the record, right? So we don't know that. All we know is we have a first action, what the causes of actions were.
It's in the oral argument and it's in the record in this case.
It is in the record as to why?
I mean, it's in the transcript that was submitted by counsel.
Okay, I'll take a look at that some more. All right.
So, and then the final thing is, my colleague referenced all of the evidence in the record supporting the prima facie case for performance. He said the deposition, all of these tick, tick, tick.
Right.
That is not in his submission, in AAM and Bevan's submission, and that violates Merritt Hill Vineyard case. That is just black letter law, and that's not sufficient. So if they want to file a new summary judgment case sufficient to meet New York law, that's one thing, but on this record, it should not be affirmed. Thank you.
Thank you. People versus Darrell Jenkins. We'll wait for Justice Kapnick to get back.
Thank you. Good afternoon.
Good afternoon. Allison Haupt on behalf of Mr. Jenkins. It is inappropriate for counsel to advocate in favor of his own client's shackling throughout trial. But that is what happened here. In pursuing his own agenda to keep Mr. Jenkins shackled, defense counsel took an adverse position against him, became
Counsel,
a
I
witness.
wasn't clear, did the people submit any memorandum of law concerning the shackling of the defendant?
No, and the court asked the people to provide case law. And what defense counsel did was to instead, he offered case law. He offered case law that definitively harmed Mr. Jenkins and asked for shackling. First, he had already said in court he wanted shackling, but then he introduced the case of People versus Cruz, which explained that the court needed to have a specific finding as to Mr. Jenkins himself and the need for shackling. And counsel distinguished People versus Cruz, where, if I can just get the language right here, as he said in Cruz, there was, quote, not an incident in court that required restraints, and he juxtaposed that with Mr. Jenkins, where he argued instead for Mr. Jenkins, there was, quote, the defendant had a violent reaction that required court personnel to restrain him. So Mr. Jenkins' own attorney is citing to case law and using it to argue that the court needs to restrain him.
I'm sorry, but doesn't an attorney have a duty of candor to the court? And so when prompted to give case law, wasn't it counsel's obligation to point out the controlling case law on the issue?
Well, first, the court didn't ask him to provide case law. That was something he chose to do on his own. Second, when a respondent makes these arguments about a duty of candor, she's citing to perjury cases where there are professional obligations preventing defense counsel from soliciting perjury at trial. That's not what we have here. He is under no obligation to present damning argument in favor of something so clearly against Mr. Jenkins' interests. The Supreme Court holds not only is shackling interfering with the presumption of innocence, but it interferes with the right to counsel, with preventing communication with your attorney, from preventing participation in your own defense. This is against Mr. Jenkins' interest, and there is absolutely no obligation for defense to argue that Mr. Jenkins should be shackled. So what do we have that's so damning? We don't even just have this case law, we have his own request. There could be nothing more damaging than defense counsel saying, I want this man shackled right next to me. Right then and there's no overcoming that. He then offers evidence against...
Well, that wasn't done in front of the jury.
I'm sorry?
It was not done in front of the jury. That statement was not made in front of the jury.
But it was said in front of the court. And what the case law says is if counsel is offering factual information that is reasonably likely to influence the decision that is against his client's interest, then we have a conflict that requires substitution of counsel.
You know, obviously the judge was in the courtroom too and observed the behavior of the defendant. And it's a cold record, you know, I wasn't there, but the defendant did appear to be acting out and did have a hard time leaving the courtroom that one time. And then eventually he did go after or allegedly, according to the record, he did, between the verdict and the sentencing, he did have a quasi-physical altercation with his defense lawyer.
Well, first, we have to look at the time at which this request is being
Right,
made.
that happened after, I know.
Anything that happened later I don't think is relevant, or it is not relevant to this consideration. Second, no matter if there was some other basis that conceivably the court could decide for shackling for Mr. Jenkins, he's entitled to an advocate to advocate for him, not to say, yes, you know, maybe you could go the other way, but no, shackle him right now. Here's the case law to support it. Here's evidence.
Well, wasn't
I'm
the
offering.
shackling done in a way that was as unobtrusive as it could have been under the circumstances? They had bunting around the table, so it wasn't particularly obvious that this was happening. And that.
Well, regardless of whether or not that was obscure, there's still no doubt that shackling is against Mr. Jenkins' interests. It's not just the presumption of innocence that's at stake, as United States versus Deck says. It's about participating in your defense, communicating with your lawyer. What counsel is
But how
saying
did that prevent him from communicating with his lawyer?
Well, first, we don't need to show that. There's no harmless analysis here, and so we don't need to show that it actually interfered. It's just that clearly this is against Mr. Jenkins' interest, and counsel took a stance adverse to that, pursuing his own agenda instead of Mr. Jenkins' interests. And if I may just say, at the point at which counsel is afraid of Mr. Jenkins such that he needs to restrain him at all times, that's the point in which he needs to be asking to be relieved, not saying, please shackle him. So while we don't need to prove that it interfered, there are numerous ways that it interfered. About he's asking the court officers to keep a safe distance between him and Mr. Jenkins so that they can't communicate with one another, asking that he remain shackled even when in a holding cell behind bars. Of course, that's interfering with the relationship, and in fact, proving the breakdown of communication and trust that Mr. Jenkins had been trying to explain to the court. But also, we see in the record that Mr. Jenkins was denied an advocate. 2 days into the trial, behaving well, Mr. Jenkins was forced to advocate for himself. He was forced to ask the court, can you please consider removing these shackles? Defense counsel stayed silent. It's the clearest example of failing to act as counsel, offering advocacy to Mr. Jenkins. And we know that the counsel's opinion mattered to the court because the court said, let me talk to defense counsel about this, because he was only going to make a decision about shackling if defense counsel was okay with it. So clearly his opinion was influenced the court's decision.
Okay, thank you. You'll have a few moments on rebuttal.
Good afternoon, Your Honors. May it please the court. My name is Patricia Curran, and I represent the people on this appeal. Defense counsel did not violate defendant's right to a conflict-free counsel. In this instance, though defense counsel neglects to mention this, he opposed the shackling of this defendant. It may be that after the violent outburst by this defendant, and when the court said that the court personnel were worried about him being unhandcuffed, that the lawyer initially said, yes, me too. But when the court was actually considering whether to shackle this defendant, the counsel made clear that he opposed it. In addition, the judge in this case asked both the people and defense counsel to submit law on this issue, not just defense counsel. The record is very clear on that. And the record does not show whether the people did or did not. It certainly doesn't show that the people did not submit a law on this issue. In addition, People v. Cruz, the one case defense counsel submitted, in the end, the Court of Appeals said that the defendant in that case should not be restrained. And submitting a 1.5-page memo at the court's request certainly did not mean that this lawyer did not represent this defendant in anything but a conflict-free atmosphere.
Should the court have explored more completely the amount of time that defense counsel had met with the defendant prior to trial?
I'm sorry, Your Honor, could you repeat the first part of the question?
The defendant said that he barely met with counsel prior to trial. Should the court have inquired more completely about that?
When the defendant initially asked for a new lawyer, literally when he was sent out to trial, he made a number of allegations. He did say that he had met with his defense counsel when he was incarcerated upstate. Yes, but the record shows that that's not the only time he met with his lawyer. And certainly, as we argue in our brief, we don't know how many mail or telephone conversations there were.
What's the court's obligation in that context?
Was it the court's obligation to?
I'm asking, what else should the court have asked, if anything, to protect his right to counsel?
Well, Your Honor, the court on 2 occasions asked the defendant why he wanted a new lawyer, and the defendant failed to establish good cause to justify his eve of trial request for a new lawyer. In fact, most of the things the defendant said had nothing to do with his lawyer. He claimed that he didn't have a transcript of a tape. Turns out he did have it. He claimed that the tape didn't show anything relevant to the case. Well, we know that's not true. It showed the entire assault. He said that his lawyer, he had a problem with his lawyer and his lawyer wasn't helping him, but he didn't say anything specific, despite the court giving the defendant 2 opportunities to tell him at length what the problem was. So the court certainly properly denied this defendant's request for a new lawyer. I'd be happy to answer questions about the persistent violent sentence. If there are any, seeing none, we rest on the record. Thank you very much.
Thank you.
Counsel's incorrect that counsel didn't actually request shackling. She's referring to the point that they're in court after he's already said, please shackle him, after he's submitted the memo distinguishing Cruz and applying it to justify shackling, after he's offered harmful information. At the point at which Mr. Jenkins is finally next to him, he says in conclusory fashion, oh, please don't shackle him. It's clearly disingenuous, not for the court, solely for Mr. Jenkins, but more than that, the damage had already been done. Bunting had already been put on the tables. The court had already thanked him for the legal reference to Cruz and its application. And so anything that was said disingenuously after the fork doesn't undermine what happened before it. Certainly, the record does show that the people didn't introduce a memo. It's not anywhere in the court file. It's not on the record before you. The respondent didn't choose to submit a memo that actually existed. It wasn't offered there. And the court only asked the prosecution to submit a legal memorandum. Once counsel made it clear that he was actively saying, me too, please shackle him, then he said, sure, submit something if you have any view on this. But that was only because counsel had taken this stance that frankly, respondent doesn't cite to a single case that says that what defense counsel did here was appropriate. And that's because there's no case that exists. And how could it? Because defense attorneys should not be advocating so severely for something against client's interest.
Do we know there may have been a strategy here? Perhaps the lawyer, and again, I'm only speculating because it's out, it would be dehors the record, but maybe the client or the lawyer was afraid the client may have some sort of outburst and didn't want the jury to see that and have the jury influenced by that, and so felt that modest restraints obscured by the bunting was a fair compromise. Would this maybe better be explored on a 440 motion where we could get into the motives for counsel's tactic?
This is not an ineffective assistance of counsel claim where strategy is at issue here. This is a blatant violation of Mr. Jenkins' right to counsel where his attorney took an adverse stance against him. It introduced damaging evidence, no more damaging than him saying, shackle this man right now, and pursued his own interests instead of Mr. Jenkins. That right to counsel violation without any harmlessness, without any consideration of strategy requires reversal in this case.
Thank you.
Thank you.
IHG Harlem versus 406 Manhattan.
Good afternoon, Your Honors. Jacob Feinsteig for the appellant. 2 years ago,
So you're the buyer, right? You represent the buyer?
I represent the buyer.
Okay, and you're looking to get prejudgment interest.
That is correct.
So is there a difference between A and C, subdivision A and subdivision B of the contract, 505.05?
Well, it's 505 A and B.
Right, I just say A and B is
A and B,
easier.
well, A and B, they're completely different. The language is completely different. And the R, IHG.
Well, I noticed one big difference. I don't know if you picked up on it. A talks about down payment. B talks about deposit. Two different terms. What does that mean? Because you could drop, if you were using down payment in both sections, the argument could be said that whatever is good for the goose is good for the gander, right? You drop it down, right? But here, and I looked at the contract, throughout the contract, it says down payments with a capital D, deposits with a capital D. So what is it that you guys mean by that? Because although B says so an exclusive remedy, does it actually say damages also, like A? Or does that?
That's a very interesting question, Your Honor. But
That's what you guys got to answer that.
no, I understand what you're saying. But the focus here is something else. The focus is we're now at this point with this court has already made a determination. Determination 2 years ago. First determination this court said is that the defendants or the respondents breached the contract. That's made a determination. The other thing that the court did is said, okay, now that you've done that, last time the issue was Judge Cutler in the previous lower court decision, which was appealed 2 years ago, she said that we were entitled to have an inquest for the loss of the bargain. At that point, the respondent, or then appellant, came to court and said no, nothing to do with loss of the bargain. But at that point,
Yeah, I mean, the bottom line is, you know, you've prevailed, and the only, at least,
Yeah.
and please correct me if I'm wrong, the only issue that remains is whether or not you're entitled to prejudgment interest.
that is
right?
correct. And under the case in Dario, unless the contract is clear that we're waiving a statutory right under Section 5001.
That case also is interesting. That case dealt with I'm trying to think now.
It's the other way around.
It's well, that case dealt with, I forget who defaulted. Hang on a second. Who defaulted in that case?
That case
That was a buyer's default.
That's right. And if you
In this case here, we have a seller's default.
And the difference is, as a real estate attorney, the entire focus of the provisions are very different when it comes to the buyer defaulting or the seller's defaulting.
Right.
And that's the reason why it worked in the Dario. The Dario could be possible under the Dario's decision to say that they waived their rights to interest.
Well, you guys got to put it in the contract. Whatever, I mean, it's always controlled, the way I understood it, everything is controlled by what you write in the contract, right?
Well, the writer of the contract was the seller who wrote the contract, even though the provision says, we don't say that. but-
Counsel, why isn't it the fact that sole, the word sole, S-O-L-E, appears in A, and sole and exclusive appears in B? Why isn't that enough to say
That's,
you
and
don't
the,
get
and the
interest?
answer is very simple. The word soul in B, number one, was dealing with, look at B. B gave you two choices of remedies. One remedy is a remedy for specific performance, or you can go ahead and get your deposit back. Then if you read it, that's an election of remedy provision, saying you have only one out of two choices to pick to.
And the last time you were here a couple years ago, we said since the plaintiff had elected not to seek specific performance, its sole remedy is the return of its deposits. That's
That
what we
was the
said.
sole remedy, saying that is, if you take a look at Section 5001A, it says that every single breach of contract, there is an award for the damage. That's there. But once you have that award, you get interest on top of it. It's two separate concepts. The concept in B here is saying, okay, what is your damage? Then once you get the damage, you have a statutory right to prejudgment interest. And that's what 5001A says. And the Dario said, you have that right like other rights, and the only way you can get it is if you clearly.
And you're saying the contract is not clear.
It's not more than that clear. It's the other way around. If you look at A meets all the conditions of the Dario. B does not. B
All right,
doesn't mention one thing
let's
of the
hear
Dario.
from your adversary, and you'll have a few minutes to respond. Thank you.
Okay.
Good afternoon, Your Honors. May it please the court.
Keep your voice up, please, or
You wanna
maybe
move the mic?
move the mic up a little.
Gabriel Korinman, Lester Korinman, Karaman Massini for the respondents.
So let me just touch on what Justice Kapnick just said and Justice Mullen said about the sole and exclusive remedy in Section B, right?
Yes.
Would you agree that interest is not a remedy? Prejudgment interest is not a remedy. That's a component of damages, right?
Well,
Yeah,
the
that's a yes or no answer, I think. Is prejudgment interest a remedy or a component of damages?
definitely a remedy.
Definitely a remedy.
It's definitely a remedy.
Okay.
And that's exactly what the Dario said. The Dario basically deals with remedy. And if you look at the language in the Dario, it talks about remedy and prejudgment interest.
And how does the fact that case, the Court of Appeals case, that deals with a buyer's default rather than a seller's default, is that a distinction, or is that a distinction without a difference?
That doesn't make a difference because there's reciprocal clauses, and the fact that the language in 505A and 505B is different, it's basically they are both in the same terms that this is the sole and exclusive remedy.
Well,
and B didn't have to repeat the same language as in A.
I would agree with you if you use the word down payment in A and in B. That would be a good argument. But the fact that you use down payment and deposit versus deposit in A and B cuts a little bit against that argument there. And the Court of Appeals, this is interesting because usually when you have this kind of provision, default provision, it's in one paragraph, so everything's all roped together. Here it's split, treated differently, and I don't think I looked at all those cases. This is kind of new because none of the cases all talk about this kind of distinction, and virtually all of the cases that I looked at, unless I missed something, dealt with a buyer's default, not a seller's default.
First of all, the Dario does not require any specific terms to be included in the agreement, only that the party set forth that the return of the down payment be the sole remedy to the non-breaching party, which is exactly what B says, subparagraph B says.
Yeah.
That in the Dario, the relevant clause contained the word sole obligations in all events, no further rights. There is of no moment. All those terms are similar and mean the same, that the obligation of the obligor is limited to
You
the
know what?
return of the
You
down
just made a
payment.
very good point. You said the word remedy includes prejudgment interest. If that were the case, then why would subdivision B even have to define damages? Because remedy is, and the damages includes interest payments. Why would you even need that? If you're saying remedy includes prejudgment interest, prejudgment interest is a form of remedy. Why do we need to have to spell that out?
The fact that it wasn't spelled out doesn't mean that the parties didn't agree to an exclusive and sole remedy.
I don't know what they
Exclusive
wanted.
and sole remedy is the return of the down payment.
Okay.
Was the deposit in an interest-bearing account?
Well, that's another interesting issue. And at the Iola account, by the way, it's an interesting bearing.
Because as I read D'Addario, they stressed that there was a sole remedy, sole obligation clause or clauses, coupled with a provision for interest on the escrowed sum.
Your Honor, yes, but that was not a controlling factor. If you look carefully in D'Addario, yes, that was a consideration that the court took into account. But if you read the language, it says, the language that was used, and when you read the decision, you'll see exactly what language they're referring. They're not referring to the interest-bearing account. The language that was used, that the down payment on the property was to be the sole remedy, and again, it talks about remedy, for a breach by the purchaser, and that the seller had no further rights against purchaser, is sufficiently clear. Okay, you don't need other languages, language regarding liquidated damages or all and all.
Well, if I could, sir, I'm reading
It's
from...
sufficiently clear in the end to reach the same result. So carefully reading, we can't circumvent the decision from the D'Addario, and the D'Addario is very clear. It talks about the sole remedy. Here it says sole and exclusive remedy.
D'Addario, and I'm quoting from the majority in D'Addario, the use of the terms sole remedy, sole obligation, and no further rights by the parties, together with the provision for interest on the escrowed sum, was sufficiently clear. There's a coupling of the contractual, the sole obligation language on the one hand, and the fact that the agreement required that the sum be held in an interest-bearing account. So there was an interest, a prejudgment statutory interest substitute that was built in D'Addario.
Yes, but that's not required. And if you look in the D'Addario, that's not required, and the holding doesn't say that it's required to have an interest bearing. That's creating, it was a factor. I'm not denying that it was a factor that the Court of Appeals considered, but it's not a controlling factor. And by the way, the Iola account is an interest bearing account. And
Okay,
the plaintiff did not refer to a single case applying the D'Addario, post-D'Addario, New York State case to granting prejudgment interest despite the sole and exclusive remedy. We did cite a case, Lee versus Hutnik from 2022, Supreme Court, in the
okay,
brief.
counsel, can you wrap up because we're running over time? So I'm going to let the appellant have 2 minutes. We have your briefs and we appreciate your answering those questions. Thank you.
Thank you, Your Honor.
Just to follow up with your question, no, there is no interest-bearing account. The money was put into an Iola account. There's no interest that followed any party. Any money that was earned went to the Iola people for their purposes, but my client received nothing.
I got a very simple question. You know, we have all the case laws, we have interpretation of the contracts. At bottom, whatever the Court of Appeals have said and whatever we've said, your parties are free to contract whatever rights you want in an agreement, right?
Correct.
So that even though the Court of Appeals says X, Y, and Z with respect to prejudgment interest, your contract can take a total different view and say, oh yeah, well, you know, under certain circumstances, we're entitled to prejudgment interest. I mean, you just got to read the contract.
If you read the D'Addario made it interesting in the case. They started making comments. Okay, how can we avoid this problem? And there's a whole paragraph. how to avoid the problem.
Well, they said if the contract is sufficiently clear in the end, then you can, will always control. They said the
That's
contract
right.
language will
If the
always
contract
control.
is sufficiently clear. But all the factors that are under Dario, they're in 505A. They're not in 505B. So that's not here. So
And what's your position about prejudgment interest as a remedy as opposed as a component of damages?
let's be, just an aside, let's be realistic. When somebody's drafting a contract, this type of contract, they're not thinking their whole deal's gonna collapse. They hope to go for, they're not thinking, okay, what can we have, they went over, they had their transaction, they looked at the deal, they expected the deal to come through. They didn't expect the seller to breach the contract. They didn't expect 5-7 years of litigation involved with this case, and it dragged on, and we're here just saying, okay, let's at least get what we were entitled to under the statute. And the Dario said we're entitled.
What's the, I don't know if it's in the record, what's the amount of interest, prejudgment interest we're looking at?
We're looking at 9% on $625,000 for 7 years.
That's not small change.
That's the reason I'm here today. It's not,
Okay. Well, thank you both very much.
thank you very much.
The next case for argument is ES, an infant versus Windsor owners.
Good afternoon, Your Honors. C. Briggs Johnson for the appellant's defendants.
You represent the co-op?
The co-op, yes.
Great.
So I think there.
Let me ask you the question. It
Yes.
looks like, based on your briefs, your appeal briefs, you're focusing and zooming in on the Administrative Code point 15. Forget the other numbers. It's point 15, right?
Yeah, we're talking about notice here.
What? I thought you were talking about occupied.
No, the lead brief and the reply brief is mostly on whether we had noticed that ES, the young infant, lived in the building during the time in question.
You're not arguing that the Administrative Code, you're not making any arguments? I thought you made some arguments.
Cohabitation?
About some sort?
About the cohabitation agreement, whether we're exempt under.
Yeah.
Yeah, I think based on.
Because if you look at it chronologically, or at least for my mind, and flow chart wise, if the Administrative Code gets you out, in other words, 0.15C is it, that shows
Right.
being occupied, and you're out under that because this is the Title 14 is not applicable if there's an occupation.
Yes.
And you don't even get to notice.
That's correct.
So let's focus on now point 15 then.
Sure.
Why do you think the word occupied is satisfied here?
Well, I think, as we put in our lead brief, that if there is a cohabitation arrangement between Psy and Search, then that takes us out of the realm.
Let's talk about the evidence of that. What
Right.
evidence is there of that in the record?
Well, there is the lease agreement, which appears to be slightly ambiguous, and then there's Search's
I
testimony.
mean the sublease.
The sublease, right.
Right.
And then there's Search's testimony that says that she also lived in the apartment and she only rented part of it out.
Can you give us chapter and verse of Search's statements? Because I found her statements to be extremely difficult to understand. They seem kind of weaselly, frankly. They didn't
Yeah.
seem like she ever placed herself in the apartment at the same time as her subtenant.
Search is a problematic witness. I mean, there's no question about that. But so is Psy. And I think, just the main argument I'm making on this appeal truly is the issue of notice. The cohabitation agreement is not my main argument. And the questions on notice, and the case that I cited in my lead brief, talk about notice to management, superintendents, right? And the superintendent going.
There you have the doorman observing a child who's obviously less than 7 years old because he's a toddler. Why
Right.
isn't that enough?
Because the doorman was not under a duty to report that to management. As I point out in reply brief, point B, that unless the plaintiff can prove that the defendant had an obligation, or excuse me, that the agent had an obligation to report to the principal, that specific obligation, the doorman is not the functional equivalent of an agent for the principal. So that's why most of the case law from this court talks about the superintendent. And he's
That's
a part
Mr.
of management.
Hernandez?
Excuse me?
His name is Mr. Hernandez?
Mr. Hernandez, right.
He went to the apartment, he saw the child.
In May of 2017. That's the first time that he went to the apartment, and all they did was discuss the plumbing emergency. That's May 1st, 2017. That's in the record as well. That's his testimony.
And then sometime thereafter, there was a positive lead test.
Yes.
So why isn't that enough?
Well, that's not enough because under the case law I also cited in my reply brief, plaintiffs failed to vacate the apartment, and Search owned the apartment. So we don't have contractual privity with Cy. This is a co-op, okay? So Search owns the apartment. We sent her a notice to cure a week after we first walk into the apartment, and then plaintiffs fail to vacate the premises.
Didn't they leave by June
30th.
June 30th, 2017?
Right. And there's case law from the Second Department and the Fourth Department that says that there is a reasonable, that you can create a question of fact on notice if you show that plaintiffs failed to vacate the premises with knowledge of the alleged lane paint exposure. And that's the Ochitaka, excuse me, I'm going to butcher the pronunciation here, but it's 259 82nd 604.
All right, that's good enough.
Okay.
So what if you lose? You don't prevail on the notice issue. What are you left with then?
If I don't prevail on the notice issue?
Yeah.
Well,
You're
notice.
missing the administrative. You wrote this in your brief. I mean, I don't
Right,
understand why
right.
you're so hesitant about
Well,
using an
well,
argument you
think
wrote about.
Based on the questions I got from Justice Moulton, you know, I think Search is a problematic witness, right? Her testimony's all over the place, but she did say that she lived in the apartment and she only rented a certain room to Cy, right? So if
Yeah, I can't make heads or tail her. I mean, it's just all over the place.
right, but the standard for incredible as a matter of law is physically impossible, manifestly untrue. You know, do most people rent
Well,
an
the
apartment?
Supreme Court didn't even address the issue because the Supreme Court said, "Oh, you know what? It's like
Your Honor, the
the
Supreme
fact
Court.
that she said she wasn't there is just like no. I mean,
They didn't cite a case in the decision. They said Cy's numerous contacts with employees of Windsor. She had no personal knowledge of whether or not these were employees of Windsor. And
flowing back into the notice argument and you're moving away from the administrative code.
Sure.
I got it. Thank you. Thank
Yes.
you. I
Okay.
got it.
Thank you.
Okay. You represent whom?
I represent the plaintiff, Your Honor. Plaintiff?
Plaintiffs, okay. Thank you, counsel.
Good morning, Your Honors. Joshua Block on behalf of the plaintiffs. May it please the court. And may I begin first with the administrative code argument.
Thank you.
And
It's a big argument. I don't know why he raised it. He's kind of like doesn't want to talk about it.
I don't, you know, if I can go back 5 to 10 minutes before to the previous case, there's something that Your Honor said. And it's everything is controlled by the contract. And that's the case here. Everything else, parole evidence, the contract itself has very specific language. There's what certain
When you say contract, you're talking about the sublease.
the sublease, absolutely.
Right.
To begin with, they talk about it being granted as a 1-bedroom, 1-bathroom. The problem with this argument is the sublease says with 1 bedroom and 1 bathroom. That with is important. It means that's what this apartment is. It comes with this, not only that.
You haven't answered the question of occupied. What does occupied mean?
To answer that question, I think that we turn back to the other cases in which the plaintiffs have sought to show that they occupied the premises.
There's no question the plaintiff occupied.
Correct.
Question is the shareholder, whether or not she occupied
Yes.
the apartment.
So I did not find any case law that talked specifically about what that meant in terms of that administrative code.
What that word, what the meaning occupied means.
Correct. And so what I'm saying is, in other cases in which someone has tried to show that they occupied the apartment for the purposes of that section of the administrative code, in these other cases, it was the plaintiff. And in those cases, it was more than just, oh, I occasionally went there. It was, you know, if it's the aunt's place, you can't occasionally go there. You can't occasionally spend a night there. It has to be more than that. And that's the core of it.
But in this case here, the shareholder left the furniture and her belongings, personal belongings in the apartment too.
Correct, because under the lease, that's where she rented a furnished
That's
apartment.
sublease. We're talking about sublease.
Sublease, yes, absolutely. So, and the sublease clarified who the tenant was and who the lessor was. The tenant was Cy and her family. Paragraph 12 is what says specifically that it was furnished. Paragraph 9 says it was only to be occupied by the tenant and her family. the sublease says that the tenant is Psy. And paragraph 32 of the sublease talks about the access of the landlord. And the access of the landlord, like any other sublease, this is a very common sublease, is that the landlord must give 24 hours notice to access the apartment.
But correct me if I'm wrong, her EBT, the plaintiff's EBT, she says that when she is there, the shareholder is not there, right? I think she said something to that effect.
I believe so.
And I don't think she went further and said that when she's not there, the shareholder is also not there.
I mean, Your Honor,
Those are two very distinct statements.
yes, except for the fact that, A, it was never, that question I don't believe was ever asked. Was Serge there when you were not there? And I don't know how she could possibly know what was going on when she wasn't there. I mean, that have been speculation, which, you can't use one way or the other on a summary judgment motion.
Right.
One thing she could have said was, I occupied the apartment for every single day. I was there until I vacated. I mean, that would have nailed it down, I suppose.
Sure.
But that question wasn't asked.
Exactly, Your Honor. And so, and beyond that, all this other stuff that we're discussing, Serge's testimony, it's all parole evidence to the sublease. The sublease, as Your Honor said, is controlling on the rights of the tenants.
Well, yeah.
I'm sorry, go ahead. Were Windsor or Tudor a party to that sublease?
They weren't, but they don't need to.
Why should they be bound by whatever definition that other parties have committed in their agreement?
Well, they're bound by local law 1 and their duties to go in, investigate, and repair.
No, but that's an excellent point to raise because, in terms of duties and obligations, whatever, with the liability and all that, that's true. But in terms of how you define the relationship, if the shareholder never provided that sublease to the co-op, which the co-op is contending, we didn't know about this, as Justice Higgett points out, how do you link it?
Well, Your Honor, there was...
You're going to bind the co-op to a definition that they had no idea that was even defined.
The Juarez case, the Rivas case, and the Moyes case, which are cited in our brief, show that an illegal tenant can still recover under local law 1. Local law 1 still protects illegal tenants.
We're not I'm not concerned about that. That's not, we're just trying to figure out this occupied term. How do we define it? Okay, I got it. Thank you.
Thank you, Your Honor. Unless there's no further questions.
Thank you.
Good afternoon, Your Honors. Matthew Simon of Matt Simon Law for the defendant respondent, Martina Andrea Sersch. She was a co-op, the unit.
Mr. Simon, you've heard us talk about this Occupy question. Judge Frank found that it was a feigned issue of fact that she ever was in the apartment during the time that the plaintiff was there. Can you cite as chapter and verse, record citations of where she said, yes, I was in the apartment, I occupied the apartment during this period, blah, blah, blah. Something like that?
What I could tell you, Your Honor, is when questioned on where she was and when she was there, she said she had a sick mother in Germany. She worked full-time in China for a Chinese company. She had a house in California, and she owned this co-op in Manhattan.
That didn't answer Justice Golden's question. He's a little bit more specific than that.
I know, and that is
That's all you got.
right. That is as specific as she got on the record. She did say that she never ran into a child on the times that she had been at the apartment, but I think...
Whoa, wait a minute. Back up. You just said she testified that she never ran into the child when she was in the apartment. Did you just say that?
Yes, Your Honor.
So that means she was in the apartment at some point? In the apartment doing something?
I don't know that, Your Honor.
Your client.
Well, what she said was she never was there at the same time the child was there.
That's different than saying she was never there. She's saying she was never there at the time when the child's there, which if you would take it to the next logical statement, that means that she was there, but then when she was there was no kid.
Again, the testimony was just not that specific.
I got it, thank you.
And I believe the inference may have been she swung by and picked up clothes.
She's trying so hard to avoid that 18% surcharge that this is just turning everything on its head.
Well, Your Honor, that was the testimony.
You got what you got.
Well, you're stuck with the testimony. We get it.
No, you're stuck with it, we're not. Okay.
Correct, Your Honor. I will say that, I don't know if this was mentioned, Dr. Search testified that there were 2 lease agreements, one where it was checked off that there was a child under the age of 12 living there, and one that there was not checked off because for the window guard.
Window guard notice.
For that purposes. So I think that's an issue on notice.
Yeah, but you know what? The whole notice, from the way I look at it, let's assume you satisfy the notice, and then I agree. Assuming I agree, no. Let's just say assuming the notice is locked down that you guys approved that, you still have to get over the administrative code, because that's another hurdle to get over, because it provides for an out for the co-op if she occupies the apartment. So, all this aside, I think that's a real big problem, right?
Well,
it's a big issue to get over, a hurdle to get over.
Your Honor,
You agree with that?
I think that's a big hurdle, and I think it was properly.
Never decided, though. Supreme Court never addressed it. Or the only thing the Supreme Court addressed was saying the management company is out under the administrative code. That's it.
My reading, I guess, the inferences in the order was that the judge didn't believe Search's testimony that she was there, and they found she was not an occupier, and there's nothing on the record that says that opinion or that finding was against law. Briefly, Your Honors, I just want to touch the indemnification clause, because that's what really affects my client, because the lower court found the indemnification clause my client agreed to with the landlord was unenforceable and void as a matter of law, because it was overbroad and it tried to include the owner's own negligence.
No, that's a good point, because point 15, the administrative code, if she is not occupying the premises, the provision provides for shifting of responsibilities, so that I would think there could be an argument that the indemnification clause, I'm going to write this down, that the shifting is okay, and that paragraph 7 of the indemnification clause is not void under the general obligations law, and that's only if she's not occupying it. Because if you read the administrative code, there's one section that says that whatever we have here doesn't affect shifting of responsibility. So that if that's the case here, the paragraph 7 that you're arguing would still be good, right? It wouldn't be, that you wouldn't be responsible.
Yes, Your Honor, but the argument, as was in the papers, was that this had no specificity at all. It was overbroad. It included not only the lessor's negligence, it included any agent, any person, anyone dwelling or visiting. There was absolutely no restriction whatsoever. It was overbroad under every aspect, including the case law I cited of Baker and N.A.
Okay, thank you.
Thank you, Your Honor.
Your Honors, finally, getting back to Justice Owen's main point about the what is occupation, right?
Thank you.
Okay, so
why
I have an
I was like in
18-month-year-old
another
son. He woke me up 25 times last night. It's not a legitimate excuse, but I finally have recalibrated myself, and I understand
I
where
was
you're
up all
going.
night, too.
Yeah, probably reading my brief.
Amongst others.
Oh, trying to read the plate at the, well, whatever.
So we have the lease, right? Search says, I only rented 2 rooms, okay? She rated that she only rented the bathroom and the bedroom to Cy, but not the living room or the kitchen. That's 438, 425, 425. She also said that she stayed in the apartment in New York with Cy, okay? Every time she was in New York.
Give us the record.
603 to 604. Whenever she slept in the apartment, she slept in the living room on a pull-out sofa, 597. That made sense because she owned the apartment. She rented a portion of the apartment.
This is the shareholder's testimony you're
Yes,
quoting.
this is Search's testimony, right. And she said anytime she rented the apartment, because she rented it out once before at least, she only rented out 2 of the 3 rooms and not the entire apartment, 426 to 427. All the relevant testimony on this issue is at 425, 438, 126, 439, 457.
I mean, it doesn't even really make sense to me. How do you rent out 2 of the rooms? So what happens to the bathroom? They don't let her use it? I mean, there's 1 bathroom in an apartment, there's 1 kitchen, certain people don't eat and certain people don't go to the bathroom.
Yeah, I mean, I wouldn't do this. I think most people wouldn't do this, but
Hey, living in Manhattan, I guess.
but it's living in Manhattan, right?
Living
I mean,
arrangements are very strange in Manhattan. let's
I
put
went to
it
the
that way.
second apartment yesterday, and I swear to God, it was a sardine can on the subway. You know, I mean, that's just New York City living. So, but as Justice Owen points out, we don't get to the notice issue if we can't get over this occupation hurdle. So, unless there's any other questions,
I just have the question that's probably in all our minds. How can you occupy an apartment if you can't use the bathroom in that apartment? But you don't know the answer to that question. I don't either.
I don't know the answer to that question.
Time management.
Time management. You know, I have my own bathroom. You know, I share it with my wife. I don't let other people.
Also,
in the neighborhood
I
use
mean, the plaintiff had 2 kids and a husband who was also there part of the time in a 500-foot apartment.
Yeah, it does sort of strain credulity. All right, well, we'll take another look at this. Thank you all
Thank you.
very
Take
much.
care.
Have a nice afternoon. Hope you get some sleep tonight. Us too.
Us too.
The next case for argument is Nava versus Franklin.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, Jeffrey Meltzer for the appellant. If there's any particular questions the court would want to address on the facts, I will kind of skip over any recitation and kind of bring one of our arguments that was third in the brief up to the fore, and that would be the issue that was addressed in the Labor Law 200 issue, and specifically as to the concept of control. Now, that issue of control specifically is important here because Labor Law 240 and 241 very much deal with control when it comes to the application of the exemption for 1, 2, and 3 family homes from strict liability. Here, Your Honor, there was a great deal of evidence submitted as to the control over the project by the husband, Mr. Emanuel, part owner.
What control over the means and methods, counsel?
The control was basically exercised through the purse strings, Your Honor. Now, if you
Oh, in other
look
words,
at,
not over means and methods. He wasn't, Mr. Emanuel, there's nothing in the record that I saw that where either defendant was saying, this is how you paint a wall, this is how you lay bricks, this is how you do anything involving construction. You know, there was the ledger book, yes.
Well-
And there's evidence that they paid some of the workers. But what about supervisory control over the means and method of the actual construction work?
well, Your Honor, the typical situation with a homeowner is that they take a sum of money, they drop it on a contractor and say, do what you got to do. And in that recognition, that's when they get exempted from strict liability. Here, if you look at page 686 of the record, there's a spreadsheet that has day-by-day purchases of things like purchase of bolts, purchase of cement, advance pay to Carlos, Home Depot materials. What you will not find in this spreadsheet, and the most important point here, is purchase of a scaffold, Your Honor. There was no GC on this project. Remember, in the record, BCS contracting had been let go because Mr. Emanuel stopped paying them.
So, counsel, I have a question.
Yes.
You know, with respect to the homeowner's exemption, you're not disputing that that applies, right, for 240 and 241 subdivision 6?
I am disputing it, Your Honor.
Why?
Because of this control.
You didn't raise, I didn't see the argument that you raised any issue with respect to defendant's direct and control to oppose the homeowner's exemption below. Did you do that? I mean, maybe I missed it.
Well, the opposition is centered around in the brief. It is.
Oh, I'm just asking a simple question. Did you oppose the homeowner's exemption by arguing below that there was no direction of control with respect to the homeowner's exemption?
Did we argue that there was no control?
Yeah.
We did not argue that, Your Honor.
So you let it go?
In opposing, well, we argued it in that the spreadsheets were presented, and in 200, there was argument of control, and that's the necessary element to defeat 200.
Right, so, okay, I'm going to get to why I asked that question, because if you didn't argue direct and control for homeowners exemption, when you go to 200 and common law negligence, you're talking about direction and control. Same direction and control, we're dealing with the same project. So if there's no direction and control on the one hand, how can there be an issue of fact, or at least something in your favor on the other hand with respect to direct and control? It's the same direction and control.
Well, respectfully, Your Honor, I believe
You follow
the issue,
that? I mean,
I believe, yeah, I do follow you.
he followed it.
I do believe the issue was raised in the papers below, and the spreadsheet was presented to the court, and therefore the issue was raised as to control in general, and therefore the brief that was submitted centered around the commercial nature of the work, which was the only way that this guy was working at a height in the first place and needed a scaffold. And again, there was also testimony on two major points. Prakash, the man who was supposed to be the general contractor, he testified under oath, I couldn't be the GC. I didn't have a license for that. I was just kind of helping the guy out. The only response that the respondent has for that is, the guy lied. That's an issue of fact at best, and it should be sent to a
I
jury.
have in my notes here that on appeal, plaintiff does not present an argument to raise an issue of fact as to whether or not defendant directed or controlled the work under 240 or 241-6.
It's buried in the 200 argument, I have to admit, Your Honor. But I believe that the record is clear and was presented to the lower court. That's why I'm bringing up an issue that...
Well, that's what I'm saying, that if you're not going to argue, if you didn't argue direction and control for 240 and 241-6, to me, that means that also that may resolve the direction and control for respect to 200 and common law negligence. There's the same direction and control, right?
I see my time is up. May I
Please answer the
and finish
question,
up?
sure.
Thank you, Your Honor. Well, in 200 here, I think it's almost impossible for the court to really uphold the court's dismissal. The guy's there every day. He lives across the street. He's watching the project every single day. He talks to...
Well, they said they're interesting, they were excited about it, they own the property, they were looking at it. I don't know how that rises to direction and control.
Well, it does, because the second level was the rental level, Your Honor, and he was very, very interested in the direction and control of the second level, because remember, that's the rental unit. That's the only reason he's working at height, and the rental unit was not with the same finishes, not with the same materials. It was being built at a much lower standard because they were not going to be occupying that. So it changed exactly the nature and the actual conduct of the construction.
Okay, let's hear from your adversary, and you'll have a few minutes to respond.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. My name is Ronnie Kravitz. I represent the homeowners, the respondents. I'm from DeSena and Sweeney. As far as the control of the property, what they did, they never told Mr. Nava what to do, how to do it.
No, but here, the way if you heard what I was trying to get at, was that if you have no direction and control so as to allow your clients to use the homeowner's exemption, that direction and control issue should be resolved with respect to the 200 and common law negligence claim, because it's the same project.
Correct.
Right?
Agree.
So I don't understand how we can say, oh, it's good for one side, but it's not good for the other issue.
Well, that's my argument.
And the thing is, if you want to peel it back even some more, the scaffold, it's not a premises liability because it's a method and means situation, because the scaffold collapsed. And I didn't see anything in the record where your clients were directing and controlling how to put the scaffold up.
And they did not do that. You know, yes, they live next door.
As Justice Captain pointed out, they were excited. They kept looking. They wanted to see the home go up. I mean, you know.
Yeah, it seems like I don't have to make my arguments because you're making them. But I agree. I agree. This is
a
lot of people up all night.
They live next door. They entered into a contract with Mr. Ramsey from Elite Contracting, who, by the way, has defaulted in this action, has not been deposed in this action, was deposed in a workers' compensation action. Different issues there. The issue, obviously, is who was the employee there. The issues here is, are these homeowners liable under the statutes and the exceptions to these statutes? And I submit that they are not. They've met every standard that needs to be met for these homeowner exceptions, and the control issue. They didn't tell him how to create the scaffold. They weren't there. They didn't say what to use if you needed to make to use this, to make a makeshift scaffold. They don't even know.
They paid some of the workers directly because the contractor had a money problem, is that it?
Yes, Mrs. Franklin, Aretha Franklin, her name is, she kept a very detailed ledger because, yes, Mr. Ramsey ran out of money and they wanted to keep the project going to build their house. And so she kept this project going they laid out money for the project. But Mr. Ramsey from Elite was the one who said, this is who you should pay. This is how much you should pay. There were emails going back and forth from Mr. Emmanuel to Mr. Ramsey's father, who was at the job site almost every day. Who should I pay? How much should I pay these people? How much did they work?
So they were controlling who got paid. They were just, your clients were just providing the money so that the project would.
Correct, to keep the project going. They had no control over how much to pay these people, who to pay them, and they weren't paying, that's basically it. And I really have nothing more to say unless you have any further questions.
Nope, thank you.
Thank you.
If I may, Your Honor.
So are there any other cases where the fact that they are paying the workers rises to the level of control, direction and control, when they're the homeowners, they don't know who to hire, they don't know what materials to use, they're just trying to make sure that the construction doesn't stop. So they're paying the money, I get it, no one's disputing that. But how does that rise to the level of construction, direction and control?
Well, it rises to the level because of the nature of the rental property again, Your Honor. He's there making sure, no, don't use that finish. You use the nice finish downstairs, don't use it upstairs. You're making sure that you're trying to minimize your costs as much as possible for the second level. And by minimizing those costs, what happened is they're not renting a scaffold. They're supposed to rent a scaffold, but they didn't. And it's the purse strings. It's the purse strings that says whether or not that scaffold shows up. We don't know what Ramsey recommended, and actually Ramsey was nothing but the agent for Emmanuel. When counsel said Ramsey ran out of money, Elite ran out of money, that's not true. That's not true at all. It's the Emmanuels that ran out of money. And it's the Emmanuels that stopped paying the actual contractor, BCS. And it was the Emmanuel and Aretha Franklin, not the goddess of soul here, Your Honor. So let's not be swayed by that. It was.
We know that.
Yes, okay. We had to figure that. But
I think she would be building a bigger house than this.
I would have thought so, Your Honor. And not
we do have
because,
Mariah Carey's case coming up.
There's a little theme going here. That she wouldn't have been skimping on the finishes upstairs, I'm sure, as well, which is what was going on here. And that's how the means and methods were controlled. It was through the money. And again, let's not.
Do you have any other case? I mean, this seems like an unusual situation, creative but unusual. Do you have any other cases similar to this?
I would rest on the cases submitted in the briefs, Your Honor. If I might just briefly conclude. The means and methods here issue, there was, contrary to counsel's statement, there was a dangerous condition that he was looking at. They're building this makeshift, whatever you want to call it, that collapsed, and he's watching them do it. And he knows why they're doing it, and they're doing it for the rental property, and that's saving him money. And it's doing it at his agent's request, because BCS, the real contractor that he dropped the money on and said, okay, you do it, they're gone because he fired them. Thank you, Your Honor.
Okay, thank you. Thank you both very much. People versus Robbins. You may proceed.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Lamont Robbins. Despite the fact that Mr. Robbins' conduct in this case was limited to making threatening phone calls to the complainant, and despite his significant history of childhood trauma and resulting mental illness.
That history is profound, it's true, but it's not just the phone calls in this case. He has a long history of abusing, harassing this particular woman.
He does, Your Honor. We don't deny that. at all, and we're not seeking to minimize the seriousness of his
He
conduct.
pled guilty in 2016 to second-degree harassment, I believe.
He did,
He
Your
called her
Honor.
after he was arrested in this case.
Again, Your Honor, we're not seeking to minimize what he did here, but a 6 to 12-year sentence is excessive in light of the circumstances. Potentially over a decade in prison, 3 consecutive 2 to 4 year sentences is excessive under the circumstances. Again, giving the significant history, this is a person who, at the age of 7 years old, was sexually assaulted by his brother, who has struggled with mental illness ever since, whose mother's boyfriend was abusive, beat him, beat his mother, terrorized the family, driving them from domestic violence shelter to low-income housing, and who was originally offered a 2 to 4 year aggregate sentence in this case. It's true that he engaged in conduct that potentially warranted additional punishment after that, contacting the complainant again, but tripling his sentence, tripling it from 2 to 4 years to 6 to 12 was absolutely excessive under the circumstances. And this is a person who has been incarcerated for long periods of time before, and we've seen what it's done to his mental health. It has caused it to deteriorate. He did not receive adequate mental health care in prison before. To the contrary, he was held in solitary confinement, beaten by guards. There's no reason to expect a different result with this incarceration. And so what we're asking for here is a sentence reduction that will at the very least allow the parole board to review whether he should be released.
Do you have a valid waiver here?
It's absolutely not a valid waiver, Your Honor. Because it has none of the hallmarks of the things that the court needs to do to ensure that the waiver is valid. It doesn't explain what an appeal is. It doesn't say it's separate and distinct from the other rights that are being given up. It doesn't say that certain claims will survive the waiver of appeal. And I'll direct Your Honors to page 10 of the plea proceedings. The sum total of the appeal waiver here is you understand that means you're giving up the right that right to take this case to any higher court. That's it. That's not only deficient, it's affirmatively misleading because it suggests that Mr. Robbins is completely giving up the right to appeal. So the appeal waiver is no barrier to this court's review in this case.
Okay, let's hear from your adversary. You'll have a minute on rebuttal.
Thank you.
Thank you.
Thank you, and may it please the court. Charles Hickerson for the people. Your Honors, to begin with, the appeal waiver is valid, and therefore this defendant's excessive sentence claim.
Counsel, there was a one sentence from the court with very little information, and you would agree that under People v. Okendo, the written repeal waiver is not sufficient to cure that, correct?
That's correct, Your Honor, and there's no doubt that the appeal waiver, the oral colloquy here could have been longer. I'm not going to dispute that, but it's a totality of circumstances standard, as Your Honors are aware. And on the totality of circumstances, this was a valid appeal waiver. There was no conflation of the other rights that he gave up with his plea allocution, Your Honors, because it was sufficiently separated. They talked about the Boykin rights.
This defendant had 2 730 examinations, correct?
Yes, sir.
Would you concede, counsel, that with people with mental health issues, that the court has to give a much more searching inquiry about what they understand that they're, what they're giving up in an appeal waiver?
Your Honor, at the plea hearing, to begin with, Justice Greenberg continually asked about defendant's state of mind. I believe it's about the first 3 pages of the plea allocution where that's mentioned, Your Honor, and to talk about very briefly those 730 evaluations. And
Counsel, I'm sorry, I don't want to divert you too much. Perhaps you should also talk about the fairness of the sentence, which is the core issue.
Thank you, Your Honor. The operative fact about the fairness of this sentence is the nature of the plea bargain. Your Honor, it's ironic that the defendant now wants the sentences to run concurrent or be modified because he had that opportunity at the plea agreement. This was a unique plea offer in which Judge Greenberg gave the defendant, over the people's objection, the opportunity to satisfy an 84-count indictment by pleading to 3 counts to run concurrently, 2 to 4, on the condition that defendant return for sentencing and not commit any new crimes or contact the complaining witness before sentencing. Why Justice Greenberg made this agreement was because he was compassionate and wanted to allow the defendant to go see his dying sick sister in Florida. As Justice Greenberg outlines in his decision and order from July 2020, defendant never went to go see his sister. He instead, immediately after the plea proceedings, proceeded to call the complaining witness and tell her, I'm going to put a bullet in your head. I'm back in the Bronx. I've been looking for you at home and work, and I'm busy on the streets selling cocaine. Now, I see my time's expired, unless you have any other questions, Your Honor.
No, I think you've pointed out the important things.
Thank-
Thank you very much. You have 1 minute on rebuttal, counsel.
Thank you, Your Honors. The key here is, at the time of the plea, for the conduct in the indictment, 2 to 4 years is what the court thought was appropriate. Now, we are not defending what Mr. Robbins did after that, but tripling his sentence, tripling
Yeah,
it.
but he was given an opportunity, unless you dispute what the adversary had just said, that the court was going to run those sentences concurrently. And it's not as if the court automatically said, no, consecutive. It's concurrent, and he just didn't abide by the conditions.
That's undoubtedly true, but that does not warrant.
True, okay.
That does not warrant an increase in sentence of this severity to go
How
from
about
2 to
the
4
point that
years
he
to
made
6.
that right after the plea, he calls up the other person and threatens them with their life?
That's true, Your Honor, but that doesn't warrant this increase in the sentence. Thank you, Your Honors.
Okay, thank you. Thank you both. The next case for argument is Morgan Carey versus Mariah Carey. Good afternoon.
Good afternoon. May it please the court, my name is Richard Altman. I'm here from Morgan Carey. First of all, what is not before the court on this appeal, interestingly enough, is the fact that there are 3 defamatory statements in the book. The defendants did not cross-appeal from those, and the fact that nor did they cross-appeal from the denial of legal fees. So that those 3 statements are not before the court, but the failure to object to the statements that were found to be defamatory, I submit, invites the court to look at all of the statements which are complained of and can make a de novo review as to their potential defamatory nature. Secondly, the statements that were made were not within the definition of public petition and participation. The details of Mariah Carey's life certainly of public interest. This book was a #1 bestseller. Everybody knows who she is.
Counsel, don't we have a lot of cases where a public figure publishes something that complains about someone who's arguably a private figure, but because it involves a public figure, it becomes a matter of public interest? And I'm thinking about Huggins. There are a couple of other cases, but Wiener. Those types of cases where it becomes a public it becomes a subject of public interest because it involves a public figure, even if they're talking about a private, arguably private figure.
Yes, that's what those cases say. But in an extreme situation like this, where it has already been determined that my client was potentially defamed, the question of whether it's a matter of public interest, I think, disappears. Because if it was privileged because of that, the court would not have found the statements to be potentially defamatory. What you have here is not, for example, an anonymous blogger posting about somebody. You don't have a patient complaining about how a physician treated her. You have
But the statute does define public interest very broadly and includes any subject other than a purely private matter. So I think it's hard to get it out of that definition.
Well, I would submit that the relation between Mariah Carey and her estranged brother and their early childhood and the treatment of their mother, and whether as a young man he was selling cocaine, which he was accused of, and the fact that he was wrongfully accused of asking for money to have somebody murdered. Are these matters of public interest? I think not. I know the statute, I know that the definition is broad, but we are talking here about the power of a very prominent person to effectively defame anybody who may have come across her path. That can't be. The next point, the liability for defamation is joint and severable. The statute, whatever else it may have done with respect to the standards for when something's actionable or not, as far as I can tell, did not change the long-standing rule that anybody who utters a defamatory statement is jointly liable. Everyone who utters a defamatory statement is jointly and severally liable. If Mariah Carey was found to be potentially liable for these statements, then I fail to see how the publisher can be immune. After all, publishers get indemnity agreements from
But
writers.
to survive against
precisely for the.
I'm sorry, counsel, to interrupt you, but to survive a motion to dismiss by the publisher, don't you have to show actual malice, which you'd have to concede that under the SLAPP statute, and also then you have to unpack some facts about actual malice. You can't be conclusory.
Well,
but where in the complaint are you not conclusory about actual malice? I mean, chapter and verse, have you got a paragraph or whatever in the complaint?
Where am I not?
In other words, where do you specify the facts that could give rise to an inference of actual malice?
The inference of actual malice was, first of all, the distinction between their initial motion to dismiss and their second motion to dismiss. In the initial motion to dismiss, we have affidavits which say, we just take our writer's word for it, we don't really look at anything. And that indifference is one piece of evidence of actual malice.
Well, but then you amended your complaint, and then it's game over, and then they have to go over it again. They did a nude motion to dismiss. So you're just saying that that was some kind of admission or something?
I'm saying that that was a change of position, and that the initial affidavits, which essentially say, we just believed her because we believe all of our writers. I don't think any responsible publisher should be able to get away with saying, we always believe our writers, because of the precisely because of the potential for liability here.
Under the First Amendment, a publisher or a news outlet has some duty to investigate an account that's given to them by an author or a witness?
I'm not saying they have an obligation, but I'm saying that there's a potential liability if under the circumstances, and the circumstances are, in addition, public statements by Mariah Carey about her ex-brother and about how she was going to destroy him. Personal malice is, yes, not proof of constitutional malice, but it's some evidence of it. And under the circumstances, the question of malice should have been allowed to be explored. We move for discovery. 3211G provides for discovery under a circumstance like this, and I believe it was an error for the lower court to deny us the opportunity to question those people who were associated with the publication of the book from the publisher's standpoint.
Oh, you're just finishing up last point?
My last point is that it was in my original brief, I talked about Gottwald against Siebert, which was in the Court of Appeals, and Gottwald against Siebert has now been decided by the Court of Appeals, which said that there is a distinction between private figures and public figures. And that the question now is, well, does this malice standard apply to everybody? Because if there is a distinction between private figures and public figures, then the only test applicable to Morgan Carey's case is that of negligence, because it's at the moment not disputed that he's a private person and not a public figure. So they can't have it both ways.
Okay, counsel.
We should have had discovery, and we should, if the case goes back, we should be entitled to explore that in detail. Thank you.
Okay, thank you. Which respondent's going first?
Your Honor, from publisher defendants,
Good afternoon.
Good afternoon, Your Honor. I'm Allison Sherry of Davis Wright Tremaine, representing the publisher defendants here. I'd just like to kind of respond to my opponent's arguments here. First, his claim that the statements are not of public interest. I would note that this is the first time it's been argued. It was not actually substantively argued in any of the papers. But regardless, as Justice Kaepernick noted, this is a very broad standard in the SLAPP law, deliberately broad, anything other than a purely private matter. And in addition to those Court of Appeals cases, Huggins, Weiner, Gata, we also have this court's decision in the Gillespie versus Kling case just a couple months ago, where there was an ex-wife on a podcast talking about domestic violence, and her ex-husband had sued. That was found to be within the scope of the SLAPP law because
that would relate to statement number 2 in
it would relate to
appendix,
statement, I think
the
it's 1, 2, it's several of the
domestic violence vis-a-vis the mother, alleged domestic violence vis-a-vis the mother.
and the fight with the father and the being afraid of him. Yeah, I think there's a lot of these are kind of overlapping, but I would say that there's kind of two ways that this is a matter of public interest here. One, Mariah Carey, as you know, my opponent has noted, international superstar. This is a story about the meaning of the making of her career, what has brought her to this day, what are the experiences that have shaped her life. It is a memoir. Individually, those statements also deal with domestic violence, childhood trauma, race relations, criminal justice system. These are all individually also topics of public interest.
If we were looking at the statements alone, that would be an easy argument for me to accept. But what are we to make of your friend's point that Ms. Carey apparently made some statements in public forums that she was sort of out to get or to destroy her estranged brother? You know, the statements coupled with these purported statements made outside the scope of the book that would be suggestive of the requisite form of malice.
Sure. Well, I think that really goes to the question of actual malice and whether actual malice has been pleaded against my clients, which are the publisher defendants here. My opponent had referred to joint and several liability. That's just not the law for fault. That's the law for publication element. But in Gertz versus Robert Welch, the Supreme Court said defamation is not a strict liability tort, and it has to be shown with respect to every individual defendant, every individual statement. As to your question about what about this ill will, again, it has to be pleaded specific to the statements and specific to the defendant. So if Mr. Carey is saying that his sister doesn't like him, that doesn't mean that the publisher defendants know that any of those specific statements are false, which is what he has to show. It's not just kind of actual malice.
Did you have any obligation to check further than what you did?
They did not have any obligations, and there's been case after case. I'm going to refer you to the Dykstra case, to Stern versus Cosby, saying that a publisher is entitled to rely on their author. And Mr. Altman said, the publisher defendant said, we take our writer's word for it and we just believed her. That in and of itself is not actual malice. Believing your source is the hallmark of a lack of actual malice, because you have to show that the person didn't believe her. They believed those to be false statements.
But here's where the sort of the additional facts get blended in. So you have, or now are considered in light of the statements made in the book. You have the statements. I agree with you. I believe under the law, you're free to accept her version of events, unless you have maybe some reason to doubt them. That would be the gross irresponsibility. And so that goes back to the statements, the purported public statement she made. She was out to get her brother or to destroy him. And maybe I'm misquoting what the plaintiff attributes to Ms. Carey. Are you saying you would have to have notice of those statements or malice, the requisite type of actual malice to be visited on you if it,
I would say a couple things. First of all, I think the book is very clear that there's animosity between the siblings. I don't think that's a surprise. But to know that there is animosity between the siblings is not the same, does not mean that you know that what she is saying about their difficult relationship growing up is false. Number one. And I would point you especially, I think, to the Gross versus New York Times case, which was in this court, failure to investigate and reliance on a source, even knowing that that source may have some kind of vendetta, may have some kind of ill will. That source has ill will towards the plaintiff. That does not give the publisher the requisite knowledge of this requisite specific subjective knowledge of falsity of each individual statement that's required for actual malice. I see my time is up, so unless there's any other questions.
Okay, thank you, counsel.
Thank you, Your Honors. John Rosenberg, my colleague Matthew Geiger, for Mariah Carey. I want to not sort of get distracted by this. Mr. Altman keeps saying that the court left 3 statements intact. And
I thought there were two causes of action based on 2 statements.
There are 8 causes of action for defamation based on 9 statements. Cause of action 1 included 2 statements. It was dismissed. All respect, he can say it as many times as he wants to. The court can just read it. It's two statements.
But I was going to ask, he did also argue that the fact that you didn't appeal the leaving in of those 2 causes of action suggests something.
Yeah, and I hear that. I don't know what it suggests. I'm not a huge fan, I hope this doesn't offend the court, of interlocutory appeals. Every issue, I kind of like getting through a case. Those 2 statements, which had to do with passing out powdered party favors, the suggestion that it was drugs, could possibly be defamation per se. So we left those in. We're going to come back on summary judgment. And by the way, the anti-SLAPP statute malice requirement still protects Mariah Carey. The anti-SLAPP protections in general still apply. We decided strategically, was I right? Was I wrong? Who knows? But it doesn't signify anything that we felt it was fact-bound a little bit more than the other statements. So we left it as it is. And by the way, this joint and several liability is interesting, but it's a distraction. The malice test is different for the person who writes it, because one can say that person is in a better position to know if what he or she said is wrong than the person they tell it to. So rather than try to get those dismissed at the pleading stage, we're going to address those on summary judgment. We're confident of our position. Now, of these 7 statements that were dismissed, what is interesting to me is in Mr. Altman in the plaintiff's brief, and even after we pointed it out in our response in his reply brief, he does not argue any single statement and try to inform the court why Judge Jaffe's 28-page opinion, every single statement analyzed at a granular level. And she made great distinctions. The powdered party favors, possibly. Defamation per se is a matter of allegation. There was one about the 3 little pigs, and Mariah said her brother was the big bad wolf. Judge Jaffe said, that's opinion. Mr. Altman mentioned something about a defamatory statement that his client was involved in a potential murder for hire. He was. He took $1,200 from a woman who later killed her husband and testified about that before a grand jury. The court found that's the fair report privilege. The point is, Judge Jaffe went through every single statement in incredible detail. Some were defamatory, but not defamatory per se. No allegations of special damages. I started out my career as an appellate law clerk, and I remember it well. I never heard of an argument which is, respectfully, Your Honors, you figure it out. I'm not going to tell you what the lower court did that was wrong. I think that the argument is almost waived by not addressing each of the statements that was dismissed and trying to articulate, for Your Honors, why Judge Jaffe was wrong. Second, because my time is short, special damages require, there is a 1-sentence argument in both briefs. It's 1 sentence long that says, because Morgan lost an Italian film deal, that's special damages. It isn't. Special damages are, what are the terms of the deal? How
So
much
that was too
money?
speculative at this point.
Totally speculative. And by the way, the Pamphili affidavit that they rely on, Mr. Pamphili, the Italian producer, he doesn't even say that he read the book. What he says is, I could sense there's, some issues here. We don't want to offend Mariah Carey because she has stature. And Judge Jaffe, in a great phrase, said something like, it wasn't Morgan Carey's reputation that led the Italian film producer to cease the deal. It was Miss Carey's reputation. He decided he didn't want to tangle. And that's not special damages. Finally, there's this injurious falsehood, but he doesn't even argue those were duplicative in every respect of the 8 counts of defamation, dismissed as duplicative and a lack of special damages. I would say this, 28-page, really insightful analysis. A lot of time clearly went into Judge Jaffe's opinion. There's nothing that's been articulated that suggests that any of her findings regarding these 7 statements and these 6 counts that were dismissed should be disturbed. I'm always happy to answer questions. Otherwise, I respectfully submit.
Okay.
Thank you, Your Honors. I appreciate it very much.
Mr. Altman.
First of all, there's a footnote in my brief quoting in the record that defendant Mariah said in an interview with Oprah Winfrey that he drew first blood, meaning her brother. So, and that she referred to him as her ex-brother.
And so, sir, as I understood one of your friends to argue that animosity itself can't equate to actual malice. Do you agree with that argument?
I do.
Characterize
Yes, I do agree with it, but it can be some indication. And there's a case in my reply brief. There's a case in my reply brief, which I don't have at the moment, in which I mention a recent lower court case in which a strong display of animosity by the defendant against the plaintiff was quite strong evidence of malice. Again, I don't say it's conclusive. They are distinct. But under these circumstances, it has some weight. Secondly, the fact that I did not, in the brief, go into detail over why I thought every rejected statement was nonetheless potentially defamatory, I don't have to explain it at all in a motion, in opposition to a motion to dismiss. It is for the court to look at the complained of statements and to say, looking at them as an ordinary citizen, ordinary person reading them, are they potentially defamatory? It doesn't need complex legal analysis. It doesn't need citation. You read it, and it's pretty plain that to say that someone was passing out party favors is an allegation of dealing in cocaine. And that's exactly what Justice Jaffe concluded. So the fact there is joint and several liability, as I said, the standard for a private figure seems, on the basis of Gottwald against Siebert, to remain as negligence. And under the circumstances, whether there was negligence, whether there was malice by the publisher, what they knew, when they knew it, are properly the subjects of discovery. Finally, one last point. My friend here talks about summary judgment. Well, there is a summary judgment motion. I made it. I made a summary judgment motion in the lower court, and that is pending. That is still pending since June. And if they thought that summary judgment should have been granted in their favor, then why didn't they move for it? They didn't ask either that the judge grant it in their favor. So that's...
Well, that's somewhat outside the record, but thank you. That's somewhat outside the record, but
Yes.
in any event,
All right.
you've made a lot of points. We will certainly look at the cases and the record and the briefs carefully. Thank you all for coming in
Thank
this
you, Your Honor.
afternoon. Have a good afternoon. The next case for argument is EPAC Technologies versus John Wiley and Sons. facing here. What? Hi.
Good afternoon.
Good afternoon.
May it please the court. My name is Kevin Kim on behalf of defendant, appellant, respondent, John Wiley and Sons, Inc.
You both want summary judgment, right?
Yes, that's correct.
That's what it looks like. That's why we got two appeals going, right?
Yes, sir.
You're the publisher, so why isn't that contract that you entered into with the printing company, you know, in a sense, it says they can print outside of Edison, New Jersey, so what's wrong with that?
The issue, Your Honor,
Because
is
it's repudiation, right? You're saying, look, you know, this contract is impossible to fulfill now.
yes,
Based
it
on the
limits
sale
their,
of
right.
Edison,
So
New
it
Jersey.
limits their right to print elsewhere. You know, in Section 2E, the very first sentence, it first states primary production shall occur at the Edison facility using this specific time.
Not sole production, it says primary
Correct.
production, right?
Right. But our argument is that moving production less than halfway through the term of the contract, when there's over, I think at that point, at least 9 million books left to be printed out of the total 11 million books contemplated in the contract, goes far, far from meeting the primary production obligation. You know, I think it's, the court's analysis has to give effect to the meaning of the word primary. Primary doesn't just mean some. You know, I think we referenced the definition of primary as it's often used in terms of residences, substantial nexus.
Let me ask you a question. Did you fulfill your minimums with the what is it, IPC or
LSI, yes.
Did you guys fulfill your minimums under that contract? Because that contract that you entered into with the printer, with the printing company, got passed on because the new company, the ILC, bought the Edison, New Jersey plant. So you were doing business with them, right?
We were doing business with them. I think this may be, I'm not sure to what extent this is within the record.
Several years.
Several years, yes. It continued ongoing. LSI continued to fulfill
Under the contract that you had with the printer, right? You didn't renegotiate the contract. You were just continuing that contract, right?
So my understanding is that the pricing was that the other printer honored the same pricing. Yeah. Again, everything was.
Now,
basically,
was this contract assigned to them? They took over.
It was not for. There was a EPAC CEO advised us that they intended to assign the contract. Right. We posed the question to their CEO a few months after the sale occurred, and we never received a response. Now, every other indication we got from the other printer was that they were honoring the same obligations, they were honoring the same pricing. So from our perspective,
ILC is honoring everything. They're going to follow through.
Exactly.
You're meeting the contractual minimums.
We were working towards meeting them. I mean, there was never, LSI never brought a breach of contract claim against us.
And then lo and behold, you get this claim from the printer, the original printer, saying you owe us money because you didn't.
5 years after they sold it, yes.
You're like, wait a minute, I'm paying one side, now I'm going to pay the other. Now I got to pay you.
Exactly. And I think what's really incredible, Your Honor, is that EPAC was helping us send the orders to LSI. We were permitted to use their servers.
No good deed goes unpunished.
Apparently. But again, I want to emphasize that this is really just a question of contract interpretation. EPAC doesn't dispute that they sold these assets. So it's really, does Section 2E obligate them to retain them? And so Judge Oing, your question about, does primary production allow them to permanently move, the printing across the country?
Yeah, because how do you, if you sell your facility that you guys contracted for at Edison, New Jersey as being the primary place, using other facilities as necessary from time to time gets dramatically thrown out the window once you sell the Edison, New Jersey.
Exactly.
Because it's no longer from time to time, but permanently you're going to be doing it somewhere else.
Exactly, Your Honor.
I think your point was we wanted the Edison, New Jersey because we could be close proximity geographically, a half an hour away from the plant. Whereas the other side is saying, well, you know what, we will absorb any shipping costs and everything. But your point is, sometimes we just want to drive there, pick up our products.
That's what happened in the ordinary course, Your Honor.
Counsel, given that they also held you harmless, didn't they, in the rest of the contract, saying we will do the shipping, we'll absorb the cost, we will get these items to you as necessary?
They absorbed the shipping costs, Your Honor, but they have no way, they've kind of backtracked from this from the position they took in the lower court. At first, in the lower court, they said you'll still get the books in 5 business days. Now they've kind of abandoned that position. They'll absorb the shipping costs from San Leandro, California, or Monterey, Mexico, but we don't know how long it's going to take the books to get to Somerset, New Jersey. We don't know to what extent these books might get lost or damaged in transit.
But that's not the key. The key component here is that you went into this agreement understanding that it was only from time to time as necessary
Yes.
for you to do outside of Edison, New Jersey. That's the component, because whatever reason why you wanted Edison, New Jersey, that's all sort of sideshow. I mean, the bottom line is when you don't have Edison, New Jersey, you cannot
Exactly.
you can't fulfill this provision anymore.
Permanently moving production is completely inconsistent with that limitation, Your Honor. I believe that's all my time. If there are no further questions.
Thank you. You'll have a few minutes on rebuttal.
May it please the court, Lena Hughes on behalf of Respondent Appellant EPAC Technologies. The parties.
How is it that you selling Edison, New Jersey, and taking away that provision of the contract? I mean, it doesn't, practically speaking, you know, from a layperson's point of view, yeah, you can't print from there anymore. It's gone.
Well, that's not a repudiation of the contract for,
Why not?
for two reasons. One is that Wiley is reading this provision out of context. In context, this primary production provision was for EPAC's protection, not for Wiley's protection.
Okay.
Just to step back, the Edison facility was a new facility with limited format printing capabilities. That means it was very constrained in what it could print compared to EPAC's other facilities, including the EPAC 1 facilities. So with the primary production provision, EPAC was getting a guaranteed stream of business for its new limited format printer.
Did it print faster, the Edison facility? I mean, I thought that the EPAC 2 was a better system, a more efficient system.
That's not correct. EPAC CEO submitted an affidavit that the EPAC 1 facilities could print just as quickly, just as well, and they can print more things. Now, the thing
Then
is,
why even have this provision in there, using other facilities as necessary from time to time? You could say using other facilities, period.
So
Don't put in the second clause.
so the reason is that EPAC wanted to insist on primary production happening at its new limited format facility, but it could choose to waive that provision since it was for its benefit. But if it didn't waive it and it wanted to insist on making primary production, that second sentence says, even then, we can still sometimes print from other facilities from time to time as necessary. And that is why Wiley in the contract is required to coordinate its demands with EPAC 2's facility limitations, because this was a restraint on Wiley. It was committing to make minimum purchases of the types of orders that could be printed at this limited format printer. But listen, even if you disagreed with all of that and thought that this did impose an obligation on EPAC, that would still be not enough to rise to the level of a repudiation, because not every breach of contract is a repudiation. And here, the MSA itself shows that any failure by EPAC to make primary production at the Edison facility was not the type of breach that allowed Wiley to walk away from the contract. We know that because in the
Wait a second. Hold on a second. Hold on. Did they walk away from the contract? Because ILC purchased the Edison plant, right? And then they were doing business with ILC, or the printing was at the Edison plant was taken over by ILC, unless I'm reading this record wrong. That didn't happen?
That's not a correct statement of the record, Your Honor.
So what is the correct statement?
Well, LSI purchased the Edison facility, but it was not assigned the MSA. And in fact, Wiley knew that. It believed the MSA had not been assigned. So while it did some business with LSI, it wasn't doing business under
Then why
the
did you
MSA.
wait 5 years to tell them, or wait several years later to tell them, by the way, you lost minimums?
So that's also factually disputed. EPAC CEO submitted an affidavit in this case saying that's not true. I spoke to Wiley's Kathy Collins on multiple occasions about the fact that Wiley was not meeting its minimum commitments. Wiley told me for years they were going to make up for that failure.
Basically, the way I hear what you're saying is there's factual issues on both sides of this equation.
There is at a minimum a factual dispute that precludes judgment in Wiley's favor.
Is it your position that 2E, which is the primary production provision, that's unambiguous?
It's unambiguous in our favor. It is not unambiguous.
I think
in
there's
Wiley's
mutuality with contracts, so I don't know that, I don't think it can be simultaneously ambiguous for one reason and unambiguous.
I think it can
You're
because
talking to
there
one
are,
of the PJI
there are
authors.
other provisions in the contract that at least cast doubt on their reading of it. So, for instance, the cost provisions here show that the cost was going to be borne by EPAC based on its choice of where to produce. So if it chose to produce from California, it still had to ship within 5 days. And Wiley could still specify the delivery date. And so EPAC still had to get it there by whatever delivery date they specified.
So you could under E produce a certain amount of your output from other facilities. But how could you, consistent with the word primary, perform your contractual obligations from a facility other than the Edison, New Jersey?
So we could, because this provision was for our benefit. So much like this court's decision in JetBlue, where there was an arbitration venue provision, I see my time is up, if it's okay, I'll finish, that provided that any disputes shall be submitted in this specific venue, and the pilots didn't comply, but they didn't have to because the provision was for their benefit. The same is true here. The primary production provision was for our benefit. We weren't required to comply with it.
Okay.
Thank you.
You'll have a few minutes for rebuttal.
If I may, I'd like to address the argument, with respect to the benefits of Section 2E, that first sentence, the primary production language. Wiley of course challenges that we did not benefit from that language. At a minimum, I think it.
But Justice Higgins made an incredible point. I mean, a good point. How do you comply with primary if you sell at Edison?
They can't.
It's gone.
That's been our position since day one, Your Honor.
So even if it's drafted in favor of the printer, I mean, you can't do primary if you don't have the facility to even do primary. I mean, where are you going with that?
I've been wondering that.
Well, you couldn't do anything from there after they sold it. Right. So.
And again, what I would like to add though is this idea that EPAC needed this first sentence in order to ensure that it had dedicated capacity at this facility just doesn't bear out when you read it. Again, it's an obligation.
Yeah,
On top of that, there's minimum commitments. So
even if you didn't even have that second where as necessary, the whole point is, and it just didn't dawn me, but Justice Higgins pointed that you have primary. You can't do primary if you don't.
Right.
Justice Cabinet, you can't do anything.
And so JetBlue is really of no relevance here. Again, the airlines in JetBlue made no dispute about the fact that they benefited. Again, here, this court can and should recognize that there's a benefit to proximity. There's a benefit to proximity for the pilots to the form in which they arbitrated. Likewise here, there's a benefit to the proximity from which Wiley's books were printed and then delivered, especially when it's just 14 miles away. If there's no further questions, I'll thank you.
Thank you.
Thank you, Your Honors. I would like to just address the point that even if you thought this created a commitment for EPAC, an obligation, it still is not a repudiation because of this. The MSA specifically addresses the circumstances in which the parties wanted to relieve Wiley of their minimum purchase commitments. And what they said is Wiley's purchase commitments will be reduced only when none of EPAC's facilities are available to print, not any time that the Edison facility is unavailable to make primary production. And that shows that the parties thought about this and they concluded that this issue was not significant enough to allow Wiley to reduce its minimum purchases. At the very least, this is
You're getting to the point. Those points that you just raised, you only get to those points if, in fact, the term primary is still effective and actually, in play. You don't have primary anymore. As Justice Captain pointed out, you sold the facility. There is no primary. There's nothing there. So how do you get to the other points that you're making and you're arguing, which all flow from the primary purpose of the contract?
What I'm saying, Your Honor, is even if you thought there's a breach of contract, not every breach of contract
they're
is
not talking
material.
breach, they're talking repudiation. It's like there is no contract anymore. It's not a breach they're arguing.
No, it has to be impossible to perform. And if you look at the first section, the very first sentence lays out EPAC's core responsibility. It is to print books for Wiley. And there is no dispute whatsoever. EPAC never gave up its ability to print books for Wiley. It could print them from other locations and at no additional cost to Wiley. So at a minimum, there is a factual dispute about whether an inability to perform at Edison is sufficiently material to give rise to a total breach rather than a partial breach, as repudiation requires. And we would submit there's at least factual questions about that because EPAC's CEO testified this provision was not meant to benefit Wiley at all. Thank you, Your
Okay,
Honors.
well, thank you both very much. Have a good afternoon. The next case for argument is S. Robert versus Norma C. I believe we have the AFC and respondent counsel got here late, so I'm giving you each 3, am I correct? I was told that, so I'm giving you each 3 minutes.
Thank you, Your Honor. May it please the court, my name is Elsa Cruz Pearson. I represent the respondent, appellant Norma Colon. Your Honors, the family court erred when it granted Mr. Spencer, the appellant respondent, independent access to Jaden Spencer's medical, academic, and extracurricular records. In this case, Bronx Family Court made an order for Mr. Spencer, an absent father, to get to know his 14-year-old son through limitless therapeutic supervised visits and email communication.
You're concerned there's no ability to ensure the redaction of relevant information in the records, correct?
Sorry?
Your concern, one of your concerns you articulate is that you can't be sure that identifying information will be redacted
Yes.
from the records.
Yes, absolutely. That with this access to, it's a limitless access, basically, to all of the son's information, medical, extracurricular, and academic, without any control over who is redacting or who is giving out this information. It includes his address, which is confidential, protected by New York State's address confidentiality program. It includes phone numbers that have been changed in order to avoid the father's advances. It includes where the child will be, when he will be there. And there is no way to control who would have access to that in a situation where the father does have access to his son. The court granted him visits, limitless visits. There's a minimum number, not a maximum number.
They haven't had too many visits, have
No,
they?
he has not made any effort to visit with his child.
And the child, I'm assuming the AFC will correct me if I'm wrong, but doesn't want the father to have access to these records either.
Not at all, Your Honor, no. Any other questions?
No.
I can stop now.
Okay.
Okay.
Thank you. You can just have a seat and we'll let the AFC, you have 3 minutes if you want to add anything to that. Thank you.
Good afternoon, Your Honors. Leah Edmonds of the Children's Law Center on behalf of the child. And just to corroborate, the child most definitely does not want any contact with the father or access to the father's records.
14 years old now, right?
That's right, yeah. And it's not disputed that he's very intelligent, knows his own mind, and that's where he's at. And I also wanted to say that the father seems to have conceded the point about the forensic evaluation in his reply brief. He completely omitted to address my arguments or the mother's counsel's arguments on that point. So assuming that the issue of the records is the only one that's really live in this appeal, there really isn't much doubt that the child wants zero contact. He doesn't want the father to have his records. The order is really 9/10 of the way there. The court crafted a good way for it to put the onus on the father to resume contact with the child at supervised visits. He has to make that happen. As far as we know, he has not done that whatsoever. It's really just, and the court also asked the mother to provide information to the father about major events in the child's life, medical or educational. And while the child opposes that, it indicates that the court has the ability to craft something that would allow the mother to have control over the flow of information, which certainly is appropriate if any information is to be provided whatsoever. If the court has any questions, then I'll.
No, I think we got it, and thank you both for coming in. Have a good afternoon.
Thank you.
Forelli versus State of New York.
May it please the court, Sheldon Karasik for the appellants. We raise 3 issues in this appeal. There are 3 challenges to the vaccine mandate. The first is based upon the free exercise of religion under the First Amendment of the U.S. Constitution and under the New York Constitution. The second issue we raise goes to the due process protections which were not afforded to these to these appellants because they did not have any pre-termination or post-termination hearing. And the final argument we raise is a separation of powers argument. It is the argument that it was the legislative function to deal with public health. This is not something that the judicial branch through UCS could engage in. Let me address the first argument, which is the free exercise of religion argument. The question here is, what test do we use? And the court below used the rational basis test in determining that this vaccine mandate was constitutional. You only use that test if the law or the rule that is being challenged is neutral and generally applicable. Let's consider neutrality first. For it to be neutral, it cannot target certain religious conduct, and it cannot be discriminatory on its face. Let's first talk about targeting certain religious conduct. If you look at the supplemental form that the applicants had to fill out here, they had to only reach that supplemental form if they asserted certain types of religious claims. In other words, if they sought a religious exemption because they were opposed to vaccination, because it had to vaccination per se, or opposed to medical treatment, then they had to go onto the supplemental form and explain a whole series of questions.
Counsel, I mean, even if we agree with you that this inquiry into the sincerity of the religious beliefs shouldn't bleed into the actual truth or non-truth of that particular belief, isn't there still a right by the agency, in this case, the court system, to look into the consistency of practice by the individual?
Absolutely not. Absolutely not. And the Supreme Court makes that clear. In Thomas versus Review Board, in the Hernandez case, in a whole series of cases, what the Supreme Court says is religious beliefs don't have to be comprehensible. They don't have to be consistent. They don't have to be understandable. They don't even have to be capable of being analyzed because they're personal. There's no way that I'm able to say that you're sincere in your religious beliefs and you're not. It's impossible for another party to step into the shoes of the person claiming that religious exemption. And the Supreme Court understands that fully and articulated that in the cases I mentioned. So what is UCS trying to do? They go through a supplemental questionnaire and they ask the most invasive personal questions imaginable, looking for consistency as if it mattered. It may matter to them, but it's unlawful. It's not a proper consideration. Have you used in your life ever the following list of 50 drugs? Well, honestly, I don't remember what drugs I used when I first became an adolescent. I probably don't remember what drugs I used a month ago. But you have to go through that whole list. And it's obviously obvious what they want. They want you to say you never used it because we're looking for consistency. And then, God, if you took an aspirin 25 years ago, you have to answer a bunch of other questions. Why'd you do that? What were you thinking at the time? You can't be religious. It's the most invasive inquiry imaginable, but more to the point, it's unlawful and it's irrelevant because consistency doesn't matter. So that's to your question, Your Honor. Back to my point, I started talking about neutrality, and I was saying that it's not neutral because you only get to that supplemental form if you assert two types of religious objections to the vaccine. One, the fetal cell argument, and secondly, an argument that you're opposed to vaccines or medicine. Well, there are plenty of other religious bases for opposing this COVID vaccine. For example, this is a unique type of vaccine. It's not even a vaccine. You're getting a spike protein and you're creating the vaccine within your body. Honestly, I've seen situations where there are many objections based upon that not being permissible on a religious basis. It's the devil making something inside yourself. I'm not saying I agree with that, and I'm not saying you have to agree with that, nor does UCS have to agree with that. The point is, if you make such an assertion, you don't have to go on to the supplemental questionnaire.
Now, I know we're not controlled or bound by it, but one of your clients, Ms. Farelli, brought a case in the federal court, right? For injunctive relief, I guess a little earlier before this, and Judge Kahn wrote a very good decision about this, and he found that it was neutral. He went through an analysis and found that it was neutral. So, as I said, I know it's not binding upon us, but how did he evaluate this incorrectly, would you say?
Well, first of all, it was a decision on a preliminary injunction. Right. So the issue before him was likelihood of prevailing on.
No, I know that, but he still made this finding.
Yeah, well, I mean, but subsequent to that, Your Honor, there have been a number of decisions which have set aside this vaccine mandate. In fact, the very same mandate, UCS is involved in this case. For example, there is the recent decision of Roswell Park, which we cite. There is, more to the point here, the matter of Suffolk County, where the union PERB brought an action against UCS for the same mandate. And the arbitrator held that the procedures for granting, and it's in our reply papers, the procedures for granting the exemption were unlawful. This very same mandate, these very same parties. So these decisions were issued subsequent to Judge Kane's decision in the Northern District of New York. So there's a whole body of case law going in the other direction. Judge Neri's decision, the Baglielli decision, all sorts of decisions clearly show that the courts are finally reassessing this whole rage to vaccinate, as Judge Gorsuch says more recently in the Mayorkas decision, which is cited in the Roswell Park decision. Slowly, the turn is being made to question what is being done on constitutional grounds. That's our first argument. Perhaps I'll have time on the reply to address some of the others, unless Your Honors have some questions for me at this moment.
Let's listen to your adversary, and I'll give you an extra minute or two on, because I would like you to reach some of those points. Thank you, counsel.
Good afternoon, Your Honors. Greg Laufer from Paul Weiss on behalf of the respondents. We are not here to talk about the wisdom or efficacy of the UCS's vaccine mandate or any other mandate. Everything you just heard from my friend on the other side has been rejected by every judge in this state who has heard these arguments. I'm not sure what the reference to was to an arbitrator in Suffolk County. I argued a temporary restraining order on behalf of the UCS in the depths of the pandemic. That was before a judge in the Supreme Court out there, and he was divested of jurisdiction before he entered any ruling. Those cases were all consolidated before a judge in Albany, who thereafter denied a motion for a preliminary injunction brought by 9 or 10 unions representing various employees of the court system. There are, and actually it's kind of quaint, I think, to talk about the pandemic. The last time I was in this courtroom was in March of 2020. I sat right there. The world was about to change dramatically, as everybody in this room, and I think everybody in the country knows. In response to those circumstances, the court system took action, an action that was taken by governmental entities and private institutions across the state, all over the country, and all over the world, and it made that decision based on established health authorities from state and federal officials, and it required all of its employees subject to 2 potentially applicable exemptions, medical and religious exemptions, to get vaccinated. And under the process that the UCS imposed, as I'm sure your honors are aware, that process entailed a multi-layered review. It consisted of an 11-member diverse independent panel that reviewed the exemption requests. And I don't want to skip to the end here, but one of the things that we just heard from my friend on the other side was that there was some impermissible probing of sincerity. I actually don't know what that's a reference to. First of all, it is well established under Supreme Court precedent that it is perfectly appropriate for an employer to inquire and not just take blindly and at face value an employee's objection on exemption grounds.
There were a lot of detailed questions on that supplemental form that most of the petitioners were asked to fill out.
Yes.
About every drug you've ever taken and what was your reasoning, and it was quite comprehensive. So I don't know if
Understood, Justice Kapnick. All I will say is that you have 4 petitioners before you. 3 of them had their exemptions denied, having nothing to do with their religious beliefs or the sincerity or
because they
lack
didn't
thereof. It
fill
was because
out
they
the
didn't
form?
fill out the forms. And they were told, speaking of process, to go back and fill out the forms correctly. And for whatever reason, they refused. I don't know why.
What happens if their refusal to fill out the forms was based, had a religious grounding in it, that they didn't want to disclose the information?
Well, they did not, none of them took that position. In fact, they did submit writings that they themselves, one of them had their lawyer do it, 2 of them did it themselves. And then the 4th one said, she did say something that frankly was insincere on its face, because she objected on the basis that and she actually stated her understanding that over-the-counter medications developed with fetal cell tissue were medications that she had taken, and for whatever reason she was objecting to a vaccine that was developed using the same exact fetal cell tissue. So I'm not sure.
I understood one of your friend's points was that an adherent to whatever religion X we'll call it, doesn't have to be completely consistent in his or her beliefs or following of the tenets of religion X. And so here, is that problematic, particularly from a free exercise standpoint, that someone can, well within their First Amendment free exercise rights, follow certain tenets at certain points, but not follow certain tenets at others?
Sure. Your Honor, the answer is no, it's not problematic here. First of all, again, we're only talking about one of the 4 petitioners, and the other 3, as I said, had their exemptions requests denied on other grounds. But more importantly, it is, sorry, I just blanked for a second on the question, whether it's problematic for the exemption. Right. No, the answer is no here, because this policy was neutral on its face. It was generally applicable. All you have to do is read it. It applied to everybody the exact same way. And so because it applied to everybody in the exact same way, it's subject to rational basis under the United States Constitution, and under the New York State Constitution, all the UCS had to show was that it didn't impose an incidental burden on anybody's exercise of religion. And by the way, nobody was actually denied any rights. You don't have a continued right to employment. There is no bodily interest that was imposed upon here. Everybody was entitled to make a choice. They could leave their place of employment, or they could continue their employment and either get a valid exemption or get vaccinated. It was just that simple. And every court that has addressed that specific question about that so-called Hobson's choice has concluded the way we have advocated to this court, which is to say it was perfectly permissible for the UCS to do what it did. If there are no further questions, I thank you all.
Thank you. Mr. Karasik? I wondered if you could address some of the due process claims that you were discussing.
Sure. The plaintiffs here were vested public employees, and as vested public employees in a non-competitive classification by UCS, they were entitled to the protections of the civil service law. They had 5 years of service continuously. That made them vested. That entitled them to those protections. Those protections consist of both pre-termination opportunity to be heard, opportunity to respond before they are terminated, which didn't happen here, and post-termination adversarial hearing. That's very clear under Laudermill. It's very clear under the Second Circuit, Locurdo versus Saphir case. They were denied those rights which are provided for in the civil service law here because they were in non-competitive positions. So their due process rights were denied. Let me just address a couple of quick points made by my adversary.
Sure.
Everybody was treated the same, really. If you look at the record here, it's very obvious that the other employees whose information we provide, in fact, didn't even submit religious statements, yet they got the exemption that were denied to my clients. It's all in the record, Your
Those
Honor.
were people that didn't fill out the supplemental
No, well, first of all, it's not true that 4 didn't. 2 of the clients, Ms. Smith and Ms. White, filled out the supplemental forms, so that's a misrepresentation of the record and the facts in the case. The other 2 clients objected to it. It's very clear that it's not a requirement. It's not a requirement to fill out the supplemental form. What's a requirement is to fill out the initial form completely, all of which my clients did.
Ms. Farrelly, who didn't fill out the supplemental form, submitted a 13-page personal statement. All of the clients also signed and notarized the supplemental form. Two of them, though, Ms. Manieri and Ms. Farrelly, objected to it for the reasons in my letter for Ms. Farrelly and for Ms. Manieri, because it invaded personal medical information. And there is no requirement that it be filled out. The requirement goes to the initial exemption form, all of which my clients filled out fully. And equal treatment, I invite your honors to look at the record and see what was submitted by those who got the exemption. They talked about the law. It's your obligation under Title VII to grant it. One of them quoted 10 pages from EEOC manuals about the law requires you do this, that, and the other. Really, that's equal treatment when my clients talk only about religious beliefs? No. As applied to my clients, there is no general applicability. Because there's no general applicability, the rational basis test is inappropriate. We go to strict scrutiny. There has to be a compelling government interest here that is served by a narrowly tailored process. It's not narrowly tailored. What would be narrowly tailored would have been to continue with the masking that they had. And in fact, if the vaccine works, why does everybody have to be vaccinated? If the vaccine doesn't work, what's the whole point of the mandate? In addition,
well, they were operating at a time when in the thralls of the public health emergency, and so it's easy for us to sit back here now and Monday morning quarterback. I mean, we're talking about actions they took. 2020, 2021.
They weren't. The public health emergency was April 2020. That's when New York experienced 15,000 deaths in New York City. This is August, September of 2021.
But the court was trying to reopen, and there was still a lot of illness out, and they were trying to figure out a way of doing it.
As Justice Gorsuch said in the Mayorkas case, that doesn't mean we put the Constitution on the shelf and let it get dusty.
We still have the First Amendment.
And that's what happened here.
Okay, I know we could probably talk about this all day, but we can't talk about it all day. We have your briefs, and we
Thank you, Your
will
Honors.
certainly review everything. Thank you both for coming in. Next case for argument is NYP Holdings versus the New York Police Department.
May it please the court, Matthew Daly for the Police Benevolent Association. The court should hold that the repeal of Civil Rights Law, Section 50A, was not retroactive. And what's at issue here is 4 decades of reliance interests by police officers, corrections officers, and firefighters across the entire state who relied on the confidentiality under Section 50A when they decided how to resolve disciplinary cases.
But when the legislature enacted this provision in June of 2020, didn't they say that this was to right some wrongs? And when that's happening, isn't that sort of a trigger for making this a retroactive applicability?
Your Honor, the legislature, when they repealed Section 50A, said nothing about retroactivity. And what
that we know, because otherwise then we wouldn't be here arguing about it. It would make things a lot easier, but they didn't do it, so we have to.
And so I think what Your Honor is getting at is this doctrine about remedial statutes and whether the court should imply retroactivity when you're dealing with a remedial statute. The Court of Appeals and this court have recently held that labeling a statute as remedial is not sufficient to imply retroactivity, because you can essentially say that about any change to the law. Any change to the law is addressing some evil that the legislature has identified. But the other issue here is the label doesn't even fit. Section 50A was in place for 40 years before the legislature decided to change it. This wasn't a situation of, you have a court decision and the legislature acts immediately and amends the statute to clarify the statute. And then you can say, well, that's what the legislature always intended and they acted quickly to correct it.
In this case, you had 40 years of consistent interpretation from the courts of these records are protected. And what the courts also said repeatedly is this is a right that belongs to the police officers and the corrections officers.
Let me ask you a question. You're saying that the prior records from the date of the repeal of the 50A should not be disclosed, right? Retroactivity doesn't apply to those. Let me pose you a situation where, what if the officer has, post-repeal, has disciplinary records that are not good for him, and that he wants to use the records in the past to show that, no, a true picture of me is my employment status here, I'm a good police officer, right? Should he be allowed to do that?
Well, yes, because Section 50A expressly deals with that and said the exception to confidentiality is when the officer, the subject officer, consents.
Okay. So then, how about then, in that case, you're allowing the police officer to do that, but then you're saying that, well, you can't let the other side do that to prove otherwise, because, you see what I'm saying? I'm saying on the one hand, you're allowing the officer to give a holistic and whole picture of who he is, who he or she is, but that right or that possibility is non-existent for the other side. They can't do that.
That's the way Section 50A worked for 40 years.
It's gone. It's gone. Now you're arguing that there should be no retroactive effect under the new law with respect to those old documents. But you just said that, forgetting about 50A, it's no longer there. But would you be agreeable that if an officer wants to use something in the past that's pre-repeal, he should be able to use that in his defense, in his or her defense?
Yes, because the right belongs to the police officer. And Your Honor, what you're getting at here are value judgments. And with all due respect, these types of policy questions are questions that have to be dealt with by the legislature.
And that's exactly why we have this statute that we have now. The legislature went through these policy considerations, and after 40 years believed, you know what, time has come for us to do has come for us to change 50-A. That's what they did. They went through this, exactly what you just said.
They went through this, and what they did not say is that this repeal is retroactive. And Your
Counsel,
Honor,
the only FOIL exception that applies here, correct, is 87-2A, which provides that an agency may deny access to records that are specifically exempt from disclosure by state or federal statute, not were specifically exempt. So the legislature could have relied on that portion of FOIL to say that, okay, game over for 50A.
that's, with all due respect, Your Honor, what controls the question here is General Construction Law, Section 93. That statute specifically deals with how you deal with the repeal of a statute. And what Section 93 says is when a statute is repealed, the pre-existing rights under that statute continue as if the statute had not been repealed. So we have to act for purposes of records that predate the repeal as if Section 50A had never been repealed. There's a state statute that says that. And the only way you overcome that presumption is if the legislature gives a clear expression of their intent for retroactivity. And they didn't say anything about retroactivity. There are statements in the record about promoting accountability, but at best that's totally ambiguous because what you're dealing with here are stale records from up to 40 years ago. And the legislature just never said it was their intent to wipe away this reliance interest for these stale old records. And I'll reserve my time. Oh, I do want to, there's a waiver issue that I also want to address, which is that the lower court didn't address this issue at all. And that was completely wrong because, as I've said, the right belongs to the police officers. The agency can't waive it on behalf of the officers.
Okay, thank you very much.
Good afternoon, Your Honors. May it please the Court. I'm Jeremy Chase from Davis Wright Tremaine on behalf of the petitioners, NYP Holdings, Inc., and Craig McCarthy. I want to reframe the discussion here for a moment, Your Honors. Retroactivity is simply the wrong lens through which to analyze whether records created prior to Section 50A's repeal are subject to disclosure under FOIL. While the PBA has dressed up its argument as a retroactivity issue, it's actually asking the court to impose a prospective obligation on the NYPD to maintain the confidentiality over records that the legislature has already decided specifically should be subject to a presumption of openness and transparency.
So what you're saying, it's just one single linear line. It's not divided by the repeal of the 50A. It's just all these records.
Well,
it doesn't matter when it was, it's talking about, as Justice Moulton said, present tense, all the records are no longer, have to be disclosed with certain exceptions.
To a certain extent, that's right, Your Honor. And I would say that we have to look at what we're talking about applying retroactively. If I make a FOIL request today, and I request police disciplinary records dating back to the 1980s even, those records are subject to the law today. Now, if I submitted a request, or if I tried to reopen an old request from prior to June 2020, that would be asking for retroactive application. This is just asking the NYPD to apply the law as it is on a going forward basis. And that's what the repeal actually concerned.
The problem with that, though, seems to ignore the officer's clear interest.
Well, Your Honor,
records. There's the NYPD's interest, right, on the one hand, and the officers on the other. And sometimes those interests in a given case will overlap, and other times there will be tension between their interests. And I know that there's case law that your friend referenced that talks about how the reason why they get a place at the table in these matters is because the officer has an interest in these records and whether or not they're disclosed and to the extent to which they're disclosed.
And Your Honor, in response to that, I would say that the case law that's binding on this court that you're referring to predates the repeal. And I would also ask Your Honor to ponder what that right actually is that we're talking about that the PBA is saying is so important to them. It's the right to keep the identities and the facts behind the actions of bad actors from the public view. Now, granted, there may be some claims that are unsubstantiated, or there may be some claims that were unfounded. Well, those claims are still subject to the FOIL exemptions, such as the privacy exemption or all the other exemptions. Now, in this case, the NYPD waived those discretionary exemptions, so they're not at issue. But as a general matter, those exemptions would still apply. Now,
that's the protective element of the new statute.
Exactly, and there are additional protective elements as well, Your Honor. There's
what about the argument that this is akin to where a defendant, doesn't want gets an ACD because they're realizing that it's going to be sealed and they don't have anything, and that's why they take the plea and that's why they take an ACD. The officer here takes the sort of a quote unquote plea, doesn't dispute the disciplinary charges, and knowing that it's fully sealed, that all gets turned around. It's gone now. So what do you say about that argument?
Well, Your Honor,
they made the deal knowing full well what it is, and then 10 years down the road, the next day, the law changes and the deal's off.
Well, Your Honor, in response to that, first I would say, aside from a single paragraph in the PBA's answer below, there is not a shred of evidence that any police officer, fire officer, corrections officer ever took a plea with the consideration of confidentiality in mind. There's nothing in the records that says that. Now, assuming that it is in the record, for Your Honor, ultimately, the Second Circuit in the Uniformed Fire Association case already rejected that very argument when the PBA and other police and fire unions argued that Section 50A should be incorporated into those very plea agreements that you're referring to. The Second Circuit said, no way. They completely rejected that, and now the PBA is just repackaging that same argument. Now, whether they're trying to incorporate 50A into the plea agreements themselves, or just to talk about it in terms of some general reliance interest, which, mind you, is the only interest and right that they are asserting here, it's been rejected. And it's the same argument, and it should be rejected again.
I guess the way I look at it is that on the one hand, you're dealing with liberty interests, where a criminal defendant, on the other hand, you're dealing with employment issues. I mean, that's apples and oranges there, right?
Fair, but Your Honor, very important, and may I just...
Yes, go ahead.
This all needs to be thought about in terms of the Freedom of Information Law, which is, it embodies the state's strong commitment to openness and to public accountability. And as Your Honor stated before, the only way to apply 50A to a FOIL request is via Section 87(2)A. And 50A is no longer on the books. So there is no statute that explicitly exempts from disclosure these specific records. So I'll reserve the rest of my time for rebuttal, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the Court, Diana Lawless on behalf of the NYPD. I'm here on the attorney's fees issue. My adversary, the petitioners, have not discussed it in their main argument, but we just want to say that Supreme Court providently denied the attorney's fees. The petitioners failed to show the Supreme Court erred as a matter of law in finding they didn't show that the NYPD lacked a reasonable basis for denying the request. The court cited below, this was all within the context, as we know, the repeal of 50A. The court below cited the Syracuse and Rochester cases, which showed that it was within the novel interpretation of the legislation that both repealed the statute and enacted a new provision to the longstanding statutory scheme. So it was proper to find that there was a reasonable for the NYPD to have withheld the records when this proceeding was brought within the repeal of 50A. And then since then, in the NYCLU versus Department of Corrections case, this court, in denying attorneys' fees in pretty much the same situation in the Department of Corrections, used the same language. We believe that controls here, so we believe that it was reasonable in this circumstance to deny attorneys' fees. Unless Your Honors have any questions, we'll rest on our brief.
Okay, thank you.
So my adversary's assertion that this argument is all about hiding records of bad actors is just completely wrong and a complete oversimplification. As the court acknowledged, there are plenty of instances where an officer or a firefighter might waive their due process rights to a trial to fight baseless claims that have been made against them, just to avoid the burden and expense when they know that it's going to remain confidential. There's a statute that keeps it confidential. So why not just settle rather than incurring the burden of fighting it? So I just wanted to rebut that point. And on the point about the lack of evidence that officers did rely on this confidentiality right, that is asserted in our verified answer, which is the equivalent of a sworn statement. It was never disputed below. And in the cases that have addressed this issue, some of the courts have even taken judicial notice of the fact that, of course, officers rely on the protection of confidentiality when making decisions about how to resolve disciplinary cases.
So can the legislature's interest in robust transparency in this regard overcome the reliance interests of the officers?
If the legislature had said it explicitly, that's how you overcome the presumption of non-retroactivity. And on that point, the record is just at best ambiguous. You can make policy arguments on both sides about whether or not these records should be disclosed. And what the Court of Appeals actually requires in order for the court to find retroactivity is that the legislature considered the issue and made a decision to make the repeal retroactive. Here, there's not even evidence that the legislature even considered the retroactivity issue. And for that reason alone, there's an insufficient basis to overcome the presumption against retroactivity. Now, the Second Circuit case that my adversary mentioned just has completely nothing to do with these issues. It didn't deal with retroactivity. And in fact, the majority of courts that have addressed this issue have held that the repeal of 50A was not retroactive, and therefore the records cannot be produced in response to FOIL requests. Thank you, Your Honors.
Thank you. Counsel.
Your Honors, just two quick points. I do want to address the attorney's fees issue very briefly.
Sure.
But first, I do want to respond to that last point. The repeal of 50A was made 2 weeks after the George Floyd murder.
Yes.
No, there's not an express statement of retroactivity in the statute, but the entire purpose of the statute was to shine light on police misconduct records and to create accountability. The very nature of the statute, the Court of Appeals held in the Regina case, there is certainly no requirement that the particular words be used, and in some instances, retroactive intent can be discerned from the nature of the legislation. That's in the Court of Appeals said that in 2020.
Now, so what's the nature of this legislation, the repeal of 50A?
The nature of this legislation is to make police disciplinary records public so that people can scrutinize who is policing their streets. And to provide accountability. And it's in the legislative record. It's there. And that's exactly
So
why.
you're saying that's enough to reflect at least, if not, obviously not an explicit a statement about retroactivity, to infer that that would be something the courts could take
Absolutely.
in
It's
mind.
the nature of the legislation. And, frankly, the argument that the records are only available from June 12th, 2020 onward is just a little too cute by half, to be honest. I mean, the entire purpose of this scheme was to make these records available to the public.
Is there anything specific you want to point to from the bill jacket that demonstrates a sense of urgency, I think is the phraseology from Gleason from the Court of Appeals, that would support your position that it was intended to apply?
I mean, as it pertains to a sense of urgency, the bill itself says that it should take effect immediately. But as far as the purpose of the statute, I mean, I could read you passage after passage. For instance, Representative Salazar, which we referenced in our brief, he spoke about how finally the people who, the family of someone murdered in 1994 will know the person who the cops were who were responsible for that. Representative Gianaris said, "Let us know who the people with a history of problems are," on the date that it was enacted. Clearly, it was a backward-looking statement towards previous records. I know I'm out of time with the attorney's fees.
Just take
I'll take two seconds, Your Honor. Just briefly.
Nobody takes 2 seconds.
Nothing. 2 minutes. No, the NYPD said that. A lot of the cases that have addressed the issue of attorney's fees in these post-repeal cases have said that it's a novel issue of law. We recognize that case law exists. We would just say that here there is no novel issue that the NYPD has asserted. Yes, the PBA has raised this retroactivity question, which no question is a novel question. The NYPD never once raised that. The NYPD instead constructively denied 116 requests. They simply ignored them for a year plus, and to this day still have not responded 3 years later. There's 16 requests that they just applied a blanket privacy exemption to, which, again, this court ruled in 2013 that a blanket privacy exemption is not okay and that's a grounds for attorney's fees. And for the other cases, there were 11 other requests that they claimed that they couldn't find any records. Of course, when we filed our administrative appeal, we learned that they only searched for substantiated records and they only searched in their computerized database, which frankly would not go back past the early 2000s. So for all those reasons, Your Honor, the rest we rest in our papers.
Thank you. Thank you all very much. We'll take a further look at all these issues. And the last case for argument today, nope, not yet. The next to last case is Shapiro versus 89th Street Development. Good afternoon.
Good afternoon. Nicholas Bruno for the defendant. It is our contention that the motion court incorrectly denied defendant's summary judgment motion for 3 reasons. First, plaintiff could not consistently and accurately identify the location of her accident. Second, defendant established that the defect was trivial and non-actionable as a matter of law.
Going to the first point, why doesn't the green line that was drawn in the photograph make it very specific?
Because
as to where she fell.
She testified using that same photograph that she fell at a different location. So before the defense attorney.
She said she fell in front of the salon on the street, and then when she got the photo during the deposition, she drew a green line and made it a little bit more specific. So I don't see what the problem is there.
Just to address that quickly, that where the green line was drawn was not in front of the salon. It was 2 sidewalk flags away in front of or before the residential doorway. But to the second point.
But she was coming out of the salon, or she was walking by the salon. It was right near there. I mean, it was right, and that's it. I mean, 2 flags is not that far away. So some of the cases you cited, the differences were much more substantial, would have concerned me more. I'll let you go on.
In any event, defendant still clearly established that the defect was trivial and non-actionable. Specifically, defendant's expert, Mr. Fine, opined that
Yes,
defect.
I know what Mr. Fine said, but there was also an expert on the plaintiff's side. I know he went later. He did indicate in his report that it appeared to him that there had been changes made, that there had been some work done on it, but based upon his evaluation, he was an engineer, he could tell that the differential was a little bit more than what your expert said, and that should create an issue of fact. And, you know, we're very hesitant with some of the Court of Appeals cases, Hutchinson or whatever, to decide things about minimal defects or de minimis, you know, on a summary judgment motion.
I understand. Just a final point is, yes, he did appear, he did the site inspection 5.5 years after, but in his affidavit, he did concede that the defect was non-existent. It wasn't there.
Yeah, but their expert came back and said they did an analysis because of the years that passed and how things have changed, that based on his guesstimate, that this is the length or this is the height of the unequal slabs. So it becomes a battle of the experts at that point. Trier fact's gonna have to figure out what exactly is happening here.
We represent and rely on our brief that opinion is speculative.
Okay, well, they're gonna say your experts are speculative, but okay.
If there's no further questions.
Thank you. We'll hear from plaintiff.
May it please the court, your honors, I am Clifford Gable, the attorney for the plaintiff respondent Barbara Cover Shapiro. Your honor essentially hit all the points that I was going to make.
It's a battle of the experts now, right? I mean,
exactly. I mean, and you know,
he says you're speculative. You're going to say he's speculative.
And in terms of the location, I mean, she might not have said in front of the exact door, but it was generally outside that salon.
She was walking uptown.
What did
the
Cardozo
building was
say?
on.
The zone of danger or something? You're around there?
It could be a zone of danger, but the truth is, your honor, she's walking uptown. The defect in question is in front of the building. She falls. It's right in front of the salon. It would be as if I tripped where this chair was and I, landed in front of the podium. It's not like, she's complaining.
The thing is, she's walking. You're not looking down when you're walking. You're looking up, right? I mean, so.
Of course.
I mean,
Of course.
At least I'm looking up. I don't know. Maybe everybody's looking down.
Of course. And with respect to the plaintiff's expert's affidavit, it can't be more transparent, Your Honor. The expert actually took a photograph that was marked as Exhibit D to the defendant's motion papers. I believe it's at page 245 of the record. And he used that photograph in conjunction with a photograph that he took to show where it was ground down and where it had been ground down earlier, prior to the accident. So certainly a battle of the experts. He showed a ruler laying down on the sidewalk that measured 3/4 of an inch. But just the height differential alone isn't enough in cases like this. The plaintiff testified that the sidewalk was riveted. She used that in her testimony. She talked about the space. Clearly a question of fact exists here. Thank you very much.
Thank you.
Just very briefly, I'd like to direct the court's attention to this court's opinion in Fayol v. EW Manhattan Portfolio LP, which is 108 83rd 476. This court considered trivial the 1/4 inch height differential of a sidewalk expansion joint that did not run the width of the sidewalk. Similar to here, where our...
Well, again, I hate to interrupt you, but that is what your expert said, but the plaintiff's expert concluded that the height differential before it was ground down was 3/4 of an inch, and that was more than 1/4 of an inch, and therefore, I don't think that that's relevant. So if there's anything else you want to say, otherwise, maybe we'll rest on your record and we'll take a look. Thank you very much, and have a great afternoon. Okay, and now we have Tudor Perini versus Port Authority. Good afternoon.
Good afternoon, Your Honors. And may it please the Court, I'm Emily Anderson of Shepherd Mullen for the Plaintiff Appellants Tudor Perini Building Corporation. I'm here to introduce my co-counsel, David Roman of NIDA Roman PC of the Bar of the State of California, who is admitted pro hac vice and respectfully request that he be permitted to argue the appeal.
Okay, well, not going to fight with that now. You waited here all day, so welcome from California, and you may proceed.
If it'll please the court, thank you for allowing me to appear here, especially to represent my client, Tudor Perini, the appellant. The primary issue here concerns the issue of the...
Why is sovereign immunity even a personal jurisdiction argument? After Hyatt, the U.S. Supreme Court case, and after our case in Belfan, where we clearly said that, that sovereign immunity is a subject matter jurisdiction issue.
I think in Belfan, and I think Belfan,
I've lived and eat and dream about that case.
Well, that's the case where I believe this court, citing Morrison...
I did. I know. I wrote it.
Okay, so citing Morrison, the second department case, I think the court relied on that case primarily.
Why is it after Belfan, we have a line of cases that say that it's subject matter jurisdiction, and that the only way, and this deals with cross-border arguments here, but internally, this is the Port Authority here in New York, where the only way you're going to get around sovereign immunity is that there's going to be an explicit consent by the sovereign to sue me, to sue the sovereign. Why is that personal jurisdiction?
Well,
it's personal jurisdiction, my understanding is whether or not you can be hailed into the court based on minimum contacts.
Well, because sovereign immunity, fundamentally, it's our view, is a challenge to the personal jurisdiction of the court, the power of the court to exercise personal jurisdiction, if I may.
Yeah.
The court's case, the cases that are cited by the respondents in the trial court and in its appellants and its respondents' briefs are cases that are what the Supreme Court case concluded were drive-by.
U.S. Supreme Court case.
Yes.
Right.
U.S. Wilkins just recently defined what it considered to be a drive-by jurisdictional conclusion, and that's simply where a court concludes that a threshold fact has not been met. In this case, the threshold fact would be that you didn't comply with the procedural requirements of the suability statute.
Yeah, unless I missed something, though. I read your briefs, but nobody cited Hyatt. I don't understand why that. How can you ignore such a gigantic case that literally changed the complex of sovereign immunity?
Hyatt is a case that deals with interstate jurisdictional immunity, as did the Henry case that I just cited.
Yeah.
But in that case, the courts did not address specifically the other forms of immunity, like the immunity that Your Honor just mentioned, which is the immunity of a state in its own courts. Here, we're not dealing with the state; we're dealing with the Port Authority. But it didn't.
I'm looking at the Port Authority's answer. Unless I'm mistaken or read the wrong answer, I did not see a personal jurisdiction defense. Was there a personal jurisdiction?
No, there wasn't.
There wasn't one. Just subject matter jurisdiction. So, gone. There's no personal jurisdiction defense being asserted here.
But that
okay,
doesn't.
So you know what? Let's do other issues here. So let's.
But that's they don't assert the personal jurisdiction defense because it's their position that the sovereign immunity defense does not raise an issue that challenges personal jurisdiction. It raises an issue of subject matter jurisdiction. What I'm saying is that the statute doesn't divest the court of jurisdiction. If you fail to meet the requirements of the suability statute, the sovereign immunity that is traditional and historic to the Port Authority is restored. And then what we have then is how does the Port Authority assert its sovereign immunity, traditional immunity? And our position is that it would have to do so in the manner it did prior to the enactment of the suability statute. That asks the question is, what is the nature of sovereign immunity?
So you're saying sovereign immunity can be waived whether or not it's subject matter jurisdiction or personal?
Well, that's what the Belfan case said. That's what the Taylor case said.
Henry
quite clear
versus
that-
New Jersey is the most recent one from the Court of Appeals, correct?
Right, that's right. So it's true, there were other issues we raised. I mean, we did argue primarily that it was that sovereign immunity was a challenge to the in personam jurisdiction of the courts, but we also raised the Lapidus case in appeal, and we said that Lapidus was a case that suggested that the Port Authority can be stopped to assert its sovereign immunity defense. And I suppose it's even if it's a subject matter jurisdictional challenge, which is inconsistent truly with a subject matter jurisdictional doctrine.
I would agree. Let me that the statute, section 7107 and 7108, let's say arguably says that you can sue the Port Authority in state court, right? That's personal jurisdiction. The court has jurisdiction to hear the case, yes? That's personal jurisdiction.
It confers on the
Okay,
court.
let's confers jurisdiction. You got an absolute right to be there, no problem. So the next question is, did you comply with the 7107's procedures in continuing or maintaining your claim against the Port Authority?
And the answer here is, for assuming arguendo for the purposes of our argument concerning the nature of sovereign immunity, and the nature of interpreting the suability statute, we're positing for the argument that Tudor Perini did not comply with the conditions precedent to the statutory codification of the Port Authority's waiver.
I just asked a simple question. Did you comply with 7107?
That's a contested issue. We contend that we substantially complied, but that
Substantial compliance is what you're saying through the emails that you got, but not specifically complying with the steps that are set forth in 7107, where it has to be sworn, everything's got to be sworn, you got to serve notice of claim, 60 days, whatever, all that. But you're saying substantial compliance was done.
Well, based on the latest Court of Appeals decision in re asbestos litigation.
Got it. Thank you.
Right? Okay, but I do want to address the issue concerning waiver of sovereign immunity.
You have
Really,
30
it's a two-step.
seconds, and then you'll have to save it for...
Well, I don't think you phrase it as a waiver of sovereign immunity, as a waiver of the 7107 procedures.
No, because this is the real key here, is because what the suability statute provides is that if you don't comply, and this is what the Luciano case said, is most courts in New York have said it for many years, that if you don't comply with the statute, the suability statute conditions precedent, what it does is it restores the Port Authority's traditional sovereign immunity. So you have to then go to the next step and say, they have sovereign immunity, how do they now assert it in the litigation? They can't simply just say you didn't comply, because it restores the sovereign immunity defense. That's what the case law says. It doesn't say that the statute doesn't provide that you are kicked out of court if you don't comply for a subject matter jurisdictional defect. What it says is that if you don't comply, in fact, if you read the contrapositive, logical contrapositive of what the statute says, it says if you don't comply with the conditions, and I'm summarizing, if you don't comply with the conditions, the consent of the sovereign to waive its sovereign immunity is removed. Well, that means it's self-effectuating. The operation of the statute provides that the sovereign immunity of the Port Authority is restored. When it's restored, it has to assert it. How does it assert it? Depends on the nature and character of the sovereign immunity defense. Does it go to personal jurisdiction? Go to the subject matter jurisdiction. And then it also depends on whether they raise it timely so they don't waive it. And apparently under the New York law, you can waive it even if it's subject matter jurisdiction. That's a doctrinally inconsistent notion, but it in fact is what the court has held.
Okay, counsel.
Thank you.
I'm going to have to interrupt you. You'll have a few minutes on rebuttal. Thanks.
May it please the court, I'm Patrick Wright out of the Skadden Arps firm on behalf of Respondent, the Port Authority of New York and New Jersey. The law has been settled for longer than any of us has been alive. The state, to be sued as a sovereign, must provide its consent, and it may condition such consent on the terms that it deems proper. And if it doesn't do so, then there is no subject matter jurisdiction.
And it consent by its behavior, by continuing in litigation. I mean, Justice Maisel even talked about this in oral arguments, like, why didn't you guys bring this up earlier? And your opponent makes the point that you can imply consent by continued participation in a lawsuit without raising this issue.
So we raised this in our answer. There's no authority in New York that says that you waive this if you don't assert it in your answer. We moved to dismiss because we were sued by Tudor Perini for breach of a contract to which the Port Authority wasn't a party, but we promptly raised it.
Does it matter that you didn't mention 7108?
No, of course not, Your Honor. The 7107 is the suability statute. It says there are two express conditions precedent. The Court of Appeals has held in the Yonkers case, which they don't.
I guess the better approach is when you made your first motion to dismiss, you should have gone both ways. You should have said that there's no privity of contract, and on top of that, 7107 protects us too. So there, but you didn't do that. You went, as Justice Maisley gave you a real hard time saying it was just so much wasted resources.
Because she came here too.
You're absolutely right. And what we did is we pled it in our answer. And
Yeah, I
we
know,
promptly
it's
raised
pretty specific. 7107, you said it.
We promptly took it to Tudor Perini and said, we don't have this. We're going to move the court. What did they say in response? First of all, they said, let's stay it. The developer, their contractual counterparty, was in bankruptcy. They went to mediation. Then we said to them, well, we don't have it. They said, okay, well, we're getting our records, COVID. You'll see, we'll produce things in discovery. We had conversations around it. When it wasn't in discovery, what it was in discovery instead? Letters to the developer saying, you, developer, owe me money, Tudor Perini. I'm going to sue you in an arbitration. You need to pay me money. Now they say, well, those letters are actually noticed to the Port Authority. They don't comply with even a scintilla of the requirements in 7107.
Let me get back to this whole personal jurisdiction thing.
Sure.
Where's the personal jurisdiction here? I'm really, please.
It's an absurd
elucidate
concept,
me.
Your Honor, because we're
you're not
talking
contesting.
about
You're not
the state
contesting
in New York.
Wait, let
me finish. You
Yes.
may like what I have to say.
Yes.
You're not contesting that state court doesn't have jurisdiction over you.
Personal jurisdiction.
Yeah.
Yeah, of course.
Personal jurisdiction, right?
What we're saying.
Okay. Okay.
So Justices Higgett and Moulton were on the panel for the recent decision in McKenzie, which we cited for this court. The court said failure to comply with the suability statute deprives the court of subject matter jurisdiction. That's been the law for the last 70 years. Now, it didn't just say that in a drive-by fashion. If it were waivable, then the ruling would have had to be different. Instead, what it said was, see Yonkers, the Court of Appeals case they don't really discuss, and see Luciano, an extensive decision that looks to the Court of Appeals decision in Buckles going back to 1917, looks to the parochial bus decision. They say, oh, the Court of Appeals cases are different because they look at Court of Claims. Parochial bus doesn't look at the Court of Claims. It looks at an identical statute under the education law where a notice wasn't provided to the Department of Education. So that's not...
Ultimately, the point is it's the state or one of her entities, right? That's the point. It's not the venue or the forum, the Court of Claims or Supreme Court.
Exactly.
It's the state or the arm of a state, and when the state said we have immunity, we will consent to be sued on such terms as we will set forth, and they must be strictly complied with. There you have it. And before they did this, we had no subject matter jurisdiction over these claims.
Before the Port Authority could not be sued, causes of action against the Port Authority could not be brought. There was no subject matter jurisdiction. What did the Court of Appeals say in Yonkers? For there to be jurisdiction, there must be compliance with these conditions precedent because they are a substantive part of the right of action.
Yeah,
and in that regard, and I'll just mention this because they spent so much of the reply talking about Wilkins, Yonkers is consistent with Wilkins because in Yonkers, the Court of Appeals said these limitations are part of the substantive right and not a procedural claims processing rule, not a statute of limitations, but different.
Yeah,
law in
all
New York is
the
settled.
the U.S. Supreme Court's cases and all the cases that followed it, when they talk about sovereign immunity, the traditional scope is every state is a sovereign, and that sovereign, the state, will decide whether or not it can be sued. Plain and simple, right? And if it's not letting you sue them, then you can't sue them.
And I'd like to remark on one thing very quickly because during argument, a letter was submitted attaching 3 cases for your honors. 2 of those cases we cited in our brief. They just failed to mention them in their reply. Now they say they want to talk about them. So I'll mention them. Those are interstate sovereign immunity cases, which are wholly distinguishable from the sovereign immunity that exists in this state, as we've all been discussing, and the Court of Appeals in Henry, and this court in Belfend, which you've lived all too well, and Colt, which they don't mention. All of those cases plainly distinguish between interstate and intrastate suits against the sovereign. And this court's opinion...
for our purposes, the interstate, intrastate, the concept of sovereign immunity is the same. It's the sovereign having the authority to tell you when it will or when it consents to whether it can or cannot be sued, right?
Well, but in the sense of interstate involves common law and it involves the 11th Amendment. Intrastate here
giving me
involves the
nightmares already.
suability statute. I don't want to give you any pause there, but I do want to note that this court concluded there was no subject matter jurisdiction in McKenzie after Belfand, after the cases they cite. And Henry doesn't alter anything, and in fact distinguishes the state cases where the sovereign immunity is waived and jurisdiction exists because of the statute waiving that immunity, like in the Court of Claims cases. Completely distinguishable, and the arguments that they've made simply do not work. This court should follow New York law, not Alaska law, not Wisconsin law, New York law for the past century, and affirm the dismissal. Thank you.
Thank you, counsel.
Briefly. I heard a couple of things here. First, the notion that there was no subject matter jurisdiction that in the Supreme Court to address disputes with the Port Authority before the enactment of the suability statute is in essence false, because there are plenty of cases that pre-exist the suability
No,
statute.
Supreme Court didn't dismiss your case for lack of subject matter jurisdiction. Supreme Court dismissed the case because you failed to comply in Supreme Court's interpretation with the statute 7107. It didn't say we're dismissing for lack of subject matter without considering it. It just says you didn't comply with the statute. And then you were arguing, well, there was a waiver of the conditions of the statute because we have emails, they accepted all this, but Supreme Court rejected that.
Your Honor, that's a separate argument. That's a substantial compliance argument. That doesn't have to do with the issue with regard to waiver. Waiver is, we argued that the Port Authority waived its defense based on on his litigation conduct by not raising the defense initially when it filed its first motion.
It's their answer, though. It's interposing their
They
answer.
didn't file an answer until a year later when they had filed it, after they had filed their
They
appeal.
did explain that they were trying to get some of the documentation to say, where is this notice of claim?
Well, I know,
And you
but
said-
that's
and
true.
So there is an explanation that I read in the briefs, and I reiterated here.
If I could say this, is that the Port Authority always, like every immunity case, the sovereign, in this case the Port Authority, retains the power. It didn't delegate it to the legislature to codify forever. It's when it's going to assert its immunity or not. The Port Authority retains the immunity and retains the right to decide whether it's going to exercise that immunity or not. That way, it decides if it's going to exercise sovereign immunity. It divests the court of jurisdiction. If you want to conclude that it's a subject matter jurisdiction, we submit it doesn't. But even if that were the case, this court has held that it can be waived if it isn't asserted timely, and it isn't asserted in an answer. I'll submit that the case law we've identified in page 19 of our opening brief is Supreme Court precedent that established that it isn't appropriate for the sovereign to come in and out of the case invoking the jurisdiction of the court for the purposes of adjudicating certain issues and then subsequently asserting a sovereign immunity defense.
Okay.
That should be the case here too.
We
Thank
will
you.
review the briefs. Thank you for your visit. Thank you all for being here. Have a nice afternoon.
Thank you. Nice job.